Judiciary Committee will come to order. Will please everybody take their seat. The clerk will call the roll. Okay, thank you. I appreciate everybody being here, and I appreciate everybody being respectful of each other and each other's opinions. The first bill, I don't think the patron is here, but I'm not sure we need him. Delegate Plum, House Bill 2. There is a substitute to that. It's the universal criminal background check. What we're going to do is conform it to the Senate bill that you've heard before. Would anybody like to speak? We've got 2 minutes apiece. It's the is there a motion to adopt the substitute?
I move we adopt the substitute conforming it to Senate bill.
Is there a second?
Second.
All in favor of the motion, say aye.
Aye.
It's identical to Senator Lucas's Senate Bill 70, which was for which there was a substitute. And
Chairman.
Yes, Senator Norman.
I don't have the language with me, but I'll deal with it on the floor. The way the bill is written, it is creating a problem for the Virginia Military Institute, and I need to craft some language for them to be under the exemption session.
Okay.
So I just,
All right.
as a matter of advance notice.
Okay. You've seen the bill before. Would anybody?
Mr. Chairman, we couldn't hear without the microphone.
That's fine. Just
he's going to conform. He's going to have an amendment on the floor to protect VMI. I think he said something like that. Okay. You've seen the bill before. Would anybody like to give 1 minute aside if anybody wants to say anything? Otherwise, we'll go ahead and move. Is there a motion?
Mr. Chair, I move to report as amended with the sub.
The bill has been moved to. It's been moved and seconded to report the substitute.
And this is the same as Senator Lucas's version.
Exactly, the same as Senator Lucas's version, having to do with sales. The motion is made. Senator Delegate Plum, would you like to say something? About ready to get your bill out?
So pleasant to see you this morning. Thank you.
Okay, thank you.
May I also seriously say, we want to continue to work on this bill. I know I've heard the concerns that many have expressed, and I recognize those concerns, but there are also, I think, some remedies for that, and I think a conference committee would be the proper place to address that.
Okay, all right. Okay, it's been moved and seconded.
Mr. Chairman?
Yeah, Senator Obenchain.
There are a lot of people across Virginia who didn't like it before. They still don't like it now.
I'm sure.
We're going to make it better, Senator.
Okay, it's been moved and seconded to report the substitute to House Bill 2. All in favor vote aye. All opposed vote no.
Ayes 9, noes 4.
As 9, noes 4, the substitute has been reported to the floor. Senator Obenchain, you say something? Oh, okay, all right. Delegate Bourne, House Bill 9, reporting lost or stolen firearms. Do we have a substitute to that, or no?
I don't believe so.
Okay, all right. Explain your bill.
Yes, sir, Mr. Chairman, members of the committee. My House Bill 9 is the exact same as Senator McClellan's bill, which you all have heard before. It simply requires that a lost or stolen firearm be reported to a law enforcement agency within 24 hours of the loss or the theft. A violation is punishable by a civil penalty of $250. It also provides some immunity for those who report in good faith the loss or theft. It provides immunity for those folks if any bad things happen with that gun that's been lost or stolen. That's it. It also does not apply to antique firearms, so I'd be happy to answer any questions the committee might have.
Any questions of the patron? Again, it's identical to Senator McClellan's Senate Bill 67, which went to the floor but was defeated on the floor. All right. Would anybody like to take a minute on either side? You've heard before. If not, is there a motion?
Move bill be reported.
Would you like to say something, sir? Very quickly. We've seen it before.
Yes, thank you, John Quapis. Chesterfield, I just would suggest that 48 hours would be more reasonable time limit on this because in a period of a loss like that, sometimes you're uncertain, you don't know what's happened, you forget about this limit, and the 48 hours makes it a little bit more reasonable. And secondly, I'm not quite sure what the real point of this is, especially this penalty on the individual. The gun, it's lost, whether you find it, whether you even have the serial number or not, you're not going to be able to find it just because it's been notified that it's missing. So I don't know why this punitive effort is being imposed on the innocent gun owner.
Okay, all right.
Thank you.
Thank you very much. Do you have anything new to say?
Yes, sir.
Yeah, very briefly, give it 30 seconds.
Jonathan Romans, Richmond, Virginia. I am in support of the bill. I've heard the opponents talk about that they are opposed to the punishment. The punishment, which is a small fine, is minute in relative to the fact of the irresponsibility and laziness of the people involved in this bill. Their lack of reporting to law enforcement can do two things. Number one, it can either have a lost firearm, possibly loaded, being out there for anyone to discover. Or infinitely worse, we literally have a bad guy with a gun out there that the community or law enforcement has no knowledge about. We have had a state senator in the past lose their firearm right here in a committee hearing. So I would expect no opposition to this bill.
Mr.
Thank you.
Chair. Okay, is there a motion? Yeah, Senator Peterson?
I'd just say, we had a full public hearing on this prior to crossover, so I don't think there's
That's
anything
why we're
new to hear.
That's why we're moving along.
Yep.
Is there a motion? It's been moved and seconded to report the bill. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 8, no 7.
8-7, the bill is reported. Senator Delegate Lopez, House Bill 264, concealed handgun permits, demonstration of competence. This is similar to Senate Bill 263 of Senator Bell's. Yeah. How similar is it?
Very similar, sir. In fact, we've actually talked about making some changes. What I would hope would happen this morning, Mr. Chairman, is that we can conform this bill to Senator Bell's bill, and we can work this out in conference.
Okay.
I think we have peace in the valley after our conversations.
Mr. Motion to conform House Bill 264 to Senate Bill 263 as it left the Senate.
I'll make that motion. I'll just say, I think this is a good bill, and I think amending it to the Senate version makes it a better bill. So I'll make that motion.
Okay, fine. All right, does anybody feel compelled to say anything for 30 seconds? I'm sorry, yeah, we need to adopt, the motion, is there a motion to adopt, have we made the okay, all right. The motion's been made to conform House Bill 264 to the Senate Bill 263 as it left the Senate. All in favor of that motion say aye. Aye. All opposed, no. Okay, the motion carries. Is our motion to report the substitute? It's been moved and seconded to report the substitute to House Bill 264. All in favor of that motion say aye. Aye. All opposed, vote aye. All opposed, vote no.
He didn't speak. Ayes 9, no 6.
Okay. Now, Delegate Price.
Thank you, Mr. Chairman, members of the committee.
Yeah, Delegate Price, 421, control
Yes.
of firearms by locality.
Mr. Chairman, I have a substitute.
There's a substitute. Welcome, Delegate Price.
Thank you, Mr. Chairman.
And is there a motion to adopt the substitute? All in favor of the motion to adopt the substitute, say aye. Aye. All opposed, no. Motion carries. Would you like to explain the substitute?
Yeah, Mr. Chair, what I want to focus on is how is the substitute different from the version that passed the Senate?
Absolutely. So there are two changes, and I will note that this substitute is now in the version that has passed the House with Senator Sorvels. And the two changes we're adding on, starting with line 36 to 37, it adds, in addition to such locality, an authority or local government entity created or controlled by the locality. And so that would just include like park authorities and things that are under their jurisdiction. And then also adding in on line 39 and 40, recreation centers and facilities that are operated by the locality.
Okay. And they would still have to have a notice, is that right?
Yes, absolutely. Nothing else changed.
And an ordinance would have to be passed to do this?
Yes.
Yeah, okay, all right, just like the Senate bill, except
Yes.
with additional added items. All right, is there, been moved, we've already adopted the substitute. If anybody feels absolutely compelled, speak now or forever hold your peace. Is there a motion to adopt the substitute, to report the
Mr. Chairman.
substitute to the bill?
Mr. Chairman,
Yeah, Senator Obenshain.
there are people back there who'd like to
All right, I'll
speak.
give 2 minutes apiece. All right, 2 minutes apiece. Anybody in favor, come up very quickly. 2 minutes, and we can be strict about the 2 minutes because you've already heard the bill.
Not letting people speak.
Okay. You're against the bill. Okay.
I'm Candy Eubank. I'm in Doswell, Virginia. And what I want to say about this bill, and I'm sure it probably won't make a difference to some of you, but I conceal carry every day for the safety of me, my children, and my family. And y'all are now restricting where I can go and then take my child to learn. So now I can't go, I'm not choosing to go to a place that has no firearms and no concealed carry because I can't protect my family. And these just becomes gun-free zones, which becomes a shooting barrel for evil people that want to do bad. So now y'all are restricting where I can go and take my family because I don't have a way to protect myself.
You realize this is
Mr. Chair.
enabling legislation for a locality to do if they want.
I understand,
A lot of localities won't do it. Okay, go ahead.
But you're giving them the opportunity for everybody to do it.
Okay.
And the laws were different in place to place. We won't know where we can and can't carry because you've got all over the place different rules.
Okay.
And the law-abiding citizens that came here on Lobby Day were respectful. There was no shots fired. There was no criminal activity here. And we are good, law-abiding citizens that y'all keep taking our rights away. And we're not the bad guy. We are not the bad guy. We are law-abiding citizens. Y'all are trying to make criminals.
Mr. Chairman.
Thank you.
I think that there are a lot of people over there on the right side who think you are the bad guy.
Okay.
They're wrong.
You're absolutely right, they're wrong.
Let's get into that, avoid arguments, okay? Any factual statements?
Mr. Chairman, may I just clarify something,
Delegate
please?
Price.
With the provision that says that a locality must put a sign up that says whether or not, they are now just simply in the position that local businesses have as well. And so you would just look at the sign just like when you're going to the store.
Okay, all right, all in favor of okay. Anybody else against? All right, go ahead.
Good morning, Lori Haas with the Coalition to Stop Gun Violence. We wholeheartedly support the bill. It is permissive. No locality is required to do anything that they choose not to do. But there are people in our localities that would want to have a festival or a children's fair or an outing or an event in a park, and they would want to be able to prohibit firearms in those circumstances. This is permissive. It gives localities to do this on a case-by-case basis. We wholeheartedly support the bill. And Senator, I do not think anybody in this room is a bad guy.
Some of your colleagues do.
Thank you.
All right, very briefly.
Philip Van Cleve, VCDL. It was bad enough before. Now we're adding even more places that people can't carry. There's no exception for permit holders, who are absolutely the most law-abiding people out there, and the statistics show that. So this is an attack on gun owners.
Okay, this will be the last speaker. Okay.
Good morning, Mr. Chairman. I'm Jerry Wilson on behalf of the City of Newport News, and we support this bill. Thank
Okay.
you.
All right, is there a motion?
Mr. Chairman.
Been moved
Mr.
and
Chairman.
seconded to
Mr. Chairman.
report to the substitute.
Mr. Chairman.
Yes, Senator McDougal.
Mr. Chairman, I just want to ask Mr. Benjamin a question. If I'm reading this correct, when I'm looking on page 2 on line 36, I'm seeing it's part of a building used by a locality. And then as I read on down later in line 40, so if a locality is using a church or other private entity, VFW, for an election, then that would make the street outside of that polling place potentially illegal because that is adjacent to the facility. Mr. Chair, no.
Yes, so that's incorrect, Mr. Chairman.
Okay.
Mr. Chairman, I was just asking Mr. Benjamin his opinion.
All right.
If you don't want to, just want to pass it without talking about it, that's fine.
Steve Benjamin.
Right.
Mr. Chairman, Senator McDougal, that provision applies for permitted events.
Okay. All right. Any other questions?
Mr. Chairman.
Obenshain?
So another to Mr. Benjamin. So if the city of Alexandria, for example, has a rented office on the 8th floor of an office building, would it prohibit carrying in the entire office building?
Mr. Chairman, Senator, no, it would not.
Okay, all right. Any other questions? Senator Norman?
Mr. Chairman, I have a little different take on it, and I have great respect for Lori, where she pointed out that it was permissive. I hope everyone appreciates that, in effect, what we're going to do because of the permissive language of this, we're going to shift this debate and this very intense controversy from the General Assembly to every local government in Virginia. And if any of you have ever served in local government, which I certainly know a couple up here have, it is going to be very intense because you're going to have the same individuals that are here today or their surrogates. They're going to be fighting this out in 130 localities in Virginia. And I think it's something we ought to be mindful of.
Mr. Chairman.
All right, Senator Sherrill.
Thank you, Mr. Chairman. You know, as I said on the floor, there's currently 86 different variations of local firearm bills that are currently in code, including bills that prohibit you from carrying local ordinances that prohibit you from carrying a loaded shotgun or loaded rifle on a street. So this is nothing new. This General Assembly crossed this line decades ago. And with regard to how much fighting we're going to see, you know, I think there's a lot of localities that have already said what their point of view is about this when they pass their sanctuary resolutions. And so I think whatever discussions are going to happen are probably going to be limited to a handful of localities, probably maybe a dozen or so. So I don't really see it as being that big of a risk. I don't think it's that big of a deal.
Okay. Is there any further discussion? All in favor of the motion to report the substitute? Yes, Senator Stanley.
Thank you, Mr. Chairman. I think I'd ask council, if we could, on page 4 of this substitute, it appears that we're repealing 15.29, 15.1, which my understanding is prohibits a locality from having the authority to bring a lawsuit against a firearms or manufacturer or marketer relating to the lawful design, marketing, manufacture, distribution, sale, or transfer of firearms or ammunition to the public. And so when we're repealing that, does that open the door to those kind of lawsuits?
In my opinion, no. It reduces the,
Put it in writing.
you would have to have the cause of action first. You would have to have something recognizable under Virginia law that would create the cause of action. All it removes is the prohibition.
Okay.
Sounds like a court fight.
Any further discussion? The motion's been made to, and seconded to adopt, to report the substitute to the floor, House Bill 421. All in favor of the motion, vote aye. All opposed to the motion, vote no. All right. Okay.
Ayes 10, noes 5.
Thank you, Mr. Chairman.
5, the substitute has been reported. All right, is Delegate Sullivan here?
Mr. Chairman,
Yes.
having voted on the prevailing side by which HB 421
Okay.
passed, I now move that we reconsider that bill.
There's a motion been made and seconded to reconsider the vote. All in favor
Keep this over here.
of the motion to reconsider, vote aye. All opposed, vote no.
Ayes 14, noes 0.
He went to get coffee, so he voting yes.
Okay, all right.
Saslo, get out here.
Okay, all right, is there a motion? Motion to report the substitute, been moved and seconded to report the substitute. All in favor of the motion, sit down, to report the substitute, vote aye. All opposed, no.
Ayes 9, noes 6.
9 to 6. Vote. The substitute to 421 has been reported 9 to 6. Okay, Delegate Sullivan, House Bill 674.
I voted you, he told me cannot vote.
Good morning, Mr. Chairman.
Go ahead.
You have before you HB 674. I believe there's a substitute being handed out right now. And with this substitute, HB 674 becomes identical to SB 240, Senator Barker's bill, which I believe this committee sent to the floor last week. So the two bills are now identical. I know this committee has spent some time already on this bill, so I'll try to be brief, answer any questions. This is what's commonly called a red flag bill, an ERPO bill. It creates a mechanism for law enforcement to temporarily remove a firearm from someone who's been found by a judge to be a risk to self or others. I would simply point out to the committee members that this is a bipartisan idea that 17 other states have already adopted. It has lots of support from both sides of the aisle, including from the Republican side, starting with President Trump, Vice President Pence, and Attorney General William Barr, who has opined that ERPOs are the single most important thing we can do in this area. This also, of course, was a recommendation of the President's Commission on School Safety, which recommended unanimously that all states in the union adopt ERPO bills. So it's a bipartisan bill everywhere else, and I hope it will be here in Virginia as well.
What's the difference between this one and Senator Barker's Senate Bill 240?
With the substitute this morning, there is no difference. They are identical.
We've already heard it, okay.
I don't know whether
Mr.
that's
Chairman,
been moved.
Yeah. Senator
That's not, I don't
Obenchain.
know that that's very helpful. What I'd like to know is what's the difference between this bill and Senator Barker's bill as it left this committee?
Mr. Chair. That's what, Mr. Chairman, Senator Obenchain, perhaps I obviously wasn't clear. It is now identical to Senator Barker's bill as Senator Barker's bill left this committee.
Okay.
Mr. Chair,
No, it's not. No, it's not.
Charles, quickly out of.
I'm sorry. Mr. Chairman.
Okay.
I'm sorry, Senator Obenchain. It is now identical to how it left the floor, and it has now passed the House committee. Thank you, Senator Obenchain. I appreciate the clarification.
Okay.
Mr.
Chair,
there are some minor differences. This bill is identical to Senator Barker's bill as it is today, as it passed the House committee. Senator Barker's bill left the floor, there was a requirement that there be 2 law enforcement officers. This bill brings it back to 1 law enforcement officer. The other change is that the law enforcement officer is not required to consult with the attorney for the Commonwealth. And I'd say the last substantive change is when considering the emergency risk order, I'll say the judge or magistrate needed to consider if reasonable alternatives exist. That takes it out of, this bill takes that language out. Those are the main differences, but there is no search warrant, automatic search warrant. So a lot of the changes that was made to Senator Barker's bill on the floor are retained in this substitute.
Mr. Chair.
Senator Peterson.
So to be specific, this is still the model where the summons is issued and then the subject returns to.
Mr. Chairman, Senator Peterson, that's correct.
All right.
Well, Mr. Chairman.
Yeah, Senator Obenchain.
I don't know that folks on this side are going to be happy anyway, but we worked very hard on trying to make some of those changes, including consultation with law enforcement or with the prosecutor, 2 law enforcement officers. I would hope that we wouldn't walk those changes back.
Mr. Chairman.
At a minimum.
Senator Sherrill.
Thank you, Mr. Chairman. Speaking of the bill, the only change that was requested by the Republican caucus was the consultation with the Commonwealth Attorney. The other 2 changes that Mr. Quagliato just described were requested by the Lieutenant Governor. So, but the consultation with the Commonwealth Attorney was requested by Senator Norman, just for clarification.
Mr. Chair.
Thank you very much.
Senator Morsi.
Let me also add this, what I consider very minor change to consult with the Commonwealth Attorney is almost non-existent for the following reason. Almost all law enforcement officers that go to a magistrate, with the exception of really serious high-profile cases, go themselves to the magistrate. They discuss the case with the neutral and detached jurist, and they either issue a summons or a warrant, or they don't. This is not a major change. The other thing is we had a very robust debate in the floor of the Senate regarding police officers going and serving the emergency protective order while simultaneously issuing a search warrant. That's out. That's not included in this.
bill. So the heart of what we discussed on the floor, what left the floor, is contained in this bill. And I think, Mr. Chairman, we should report it.
Okay, any further discussion? Yeah, Senator Norman.
Thank you, Mr. Chairman. I don't have the exact language, but certainly our council knows it. I would make a motion to reinsert the language about consulting with the Commonwealth Attorney that we previously had put on at the request of the Commonwealth Attorneys Association.
It's been moved and
Mr. Chairman.
seconded. Yeah, Senator, it's been moved and seconded to reinsert the Commonwealth Attorneys in here. Senator Shorville.
Thank you, Mr. Chairman. I think speaking to the bill, so the removal of that, I believe, was requested by the Virginia Association of Commonwealth Attorneys, if I'm not mistaken. But if they're here, maybe they could clarify that, or maybe Secretary Moran can clarify that. But I believe that's why that was put in, because the Commonwealth Attorneys did not want to have that responsibility, I believe.
Anybody from the Commonwealth Attorney's office is here? Or Secretary Moran, or anybody want to speak to that issue?
If that is the case, I will withdraw it. But
Somebody.
Here comes somebody.
Jeff Hayslip, Commonwealth Attorney, Fluvanna.
Coming up so we can hear you.
President of Virginia Association of
What's your
Commonwealth
name
Attorneys.
again?
Jeff Hayslip, Commonwealth Attorney in Fluvanna. We took no position, we made no request that it be put in or taken out, so I'm not sure where that perception came from. So just wanted to make that clear.
You want to withdraw your
Mr.
motion?
Chairman?
You want
Mr.
to
Chairman?
withdraw your motion or not? No, okay. All right, Senator Shurbull. Yeah, what's the position of the Secretary?
No, as to why that language needed to come out.
Mr. Chairman, members of the committee, that was, as I understand it, amended on the floor. The Senate was not at our request at all, nor the Commonwealth's attorneys. And recognizing these cases, I don't know where else in the code where we require the Commonwealth's attorney consultation. So I think we'd be going down a new path that we don't need to do it on this particular case.
All right, is there ready, it's been
Mr.
motion
Chairman.
made and seconded to reinsert the Commonwealth attorneys. Yeah, Senator Norman.
Thomas, the Secretary is there. I know he was an extraordinary lawyer, but you might want to check 19.2 and 18.2 because there are provisions for mandatory consultation with the Commonwealth attorneys on the issues of certain felony charges.
And Mr. Chairman, as you well know here, this doesn't even contemplate a criminal violation. So I don't think that's apples and apples. So I would suggest we not adopt that amendment.
All right, is there any further discussion on the motion? All in favor of the motion to reinstate the Commonwealth attorneys, vote, say aye. Aye. All opposed, no. No. The noes have it. Okay, anything else? Delegate Sullivan?
Thank you, Mr. Chairman. My sense is that this committee spent a lot of time on this, so I won't take any
I
more.
think we are. Then move to report the substitute. Yes, Senator Stewart.
Sorry. Mr. Chairman, I'd like to ask the delegate a question, if I may. Mr. Chairman?
Yeah, go ahead. Yeah.
Delegate Sullivan, I'm fairly familiar with this, but I looked through this very quickly, and if I understand this right, if someone is deemed a substantial risk of personal injury to himself or others, that's what triggers the order to seize or go and have him turn over the firearms. Is that accurate?
Mr. Chairman, Senator Stewart, that's correct.
Okay.
Okay.
What does this bill do to get that person mental health treatment?
Mr. Chairman, Senator Stewart, the bill itself does not have any language within it, and certainly it's the kind of thing that I would agree we need to do more of. I can say, I believe there's some others here who can talk to this, that the experience in other states that have bills, that have laws like this, has been that when something like this happens, that does serve as an opportunity for family and localities to get involved when they hadn't been before, for the subject of the order to realize his or her situation. And so that has been the experience in other states, but there is nothing in this particular bill that does that. Might be something we should focus on in the future.
Mr. Chairman?
Yeah, Senator Robinson.
Well, help me, Delegate Sullivan, because if you have a bill that is determining a person as a substantial risk of personal injury to himself or others, what purpose does it serve to serve an order on him telling him to turn over his firearms? Couldn't he create havoc with a myriad of other things? And if this person is mentally disturbed, shouldn't we deal with that first?
Yeah,
Mr. Chairman,
Sullivan, go
Mr.
ahead.
Chairman, Senator Stewart. Senator Stewart, this bill is as much a suicide prevention bill as anything else.
Can you, that's my question. Can you explain
Yeah,
how
sure,
it,
sure,
how it is
sure
a
I can.
suicide prevention bill?
Sure.
If
The
it does
statistic-
nothing to get the individual mental health treatment.
Sure, sure I can. Mr. Chairman, Senator Stewart, the statistics on suicide by gun are frankly overwhelming. It is the method of choice. It is certainly the most effective form of suicide. So when a person in that kind of trouble no longer has a gun with which to accomplish that, it will cut down. It has been shown by studies in the other states that it cuts down on suicide rates very dramatically.
Okay, any further discussion on the bill?
Chairman,
Yeah, Senator.
Mr. Chairman.
All right, go ahead, Senator Overton.
Mr. Chairman, this just really concerns me because if we truly wanted to prevent suicide or any other acts, we do something to help the individual that is in need of help, rather than having an order to seize or get their firearms. It seems to me we are not addressing the biggest part of this, and that's the mental health treatment, as opposed to just trying to get people's guns.
Okay, any further discussion? All right, hold it down, please.
Mr. Chairman.
All right, yeah, Senator Stanley.
Mr. Chairman, a question of the patron. Delegate Sullivan, now that we've removed the two-officer safeguard, we've removed now the consultation with the Commonwealth's attorney before the order is issued, and now we've removed even the fact or the status that no other reasonable alternative existed before the seizure of the firearm. And since this bill is focused on, as you say, a person who may or poses a risk to himself or others, can you point to me in this bill, where in the bill, that it says that not only the firearm will be seized, but all other instruments of danger, such as knives, machetes, cars, things where someone can do harm with them to themselves or others? Is that in this bill, sir?
Mr. Chairman, Senator Stanley.
Answer the question, that's fine.
Mr. Chairman, Senator Stanley, that is not in the bill.
It's not in the bill?
Any further questions, Senator Deeds?
Mr. Chairman, I would tell Senator Stanley that if he would do any of the research, look at any of the research that's been done on suicide, and its research is scant. But the research has shown that people who intend to commit to kill themselves with a firearm are hindered when the firearm is removed, and suicide is much less likely to occur. And in the states where this legislation is passed, that's what the studies show.
Mr. Chairman.
Any further
Mr. Chairman.
questions? Senator Searle.
Thank you, Mr. Chairman. Speaking to the bill, first of all, I'm just poking around here, but according to PolitiFact, since Florida law went on the books, which this law is based on, there's been 2,396 of these types of orders issued in the Commonwealth of Florida. So far, 700 firearms have been surrendered and 135,000 rounds of ammunition. 90% of the orders that are ended up issued are ended up being issued by agreement. That is, the person who is the subject of the order doesn't dispute them. And I believe Senator Barker testified at the House Committee last week, and I've been able to verify this, but I was looking for it, that there's only been one actual criminal violation of this order in the state of Florida since it was put in place. And so while I recognize this is a change, we also currently have rules in Virginia that require the surrender of firearms when protective orders are issued for family and domestic abuse, or for protective orders issued against people who threaten each other. None of these are very new concepts, and I think that while people are uncomfortable with it, it's not going to be a big deal at the end of the day.
Okay,
We need to move this bill along.
Mr. Chairman.
Senator Stanley, I believe you had a question.
Thank you. First, again, I think we have now narrowed the focus that this bill is merely a bill to prevent suicide. So, Mr. Chairman, I would make a motion to amend this bill to only include that this would come up, this red flag law would only come up when there is a threat to themselves and not to others.
Mr. Chairman?
Senator McDougal.
If this is a suicide bill, Mr. Chairman, let's make it just a.
Mr. Chairman.
I move we report the bill as amended.
Is there a second to that motion? No, which motion?
Yeah.
Is this a substitute motion?
Mr. Chairman, I move we report the bill as amended currently.
Is there a second?
The substitute.
Okay, that's a substitute motion.
presented by-
All right, Senator McDougal.
Mr. Chairman, this is another question for Mr. Benjamin. Talk to me lines 495 through 497. In that line, it says, may obtain search warrant if the law enforcement officer has reason to believe. Previously, I thought we used an established standard of probable cause. Can you tell me what reason to believe is? I don't recall that for any Fourth Amendment search.
Probable cause is necessary for a search warrant.
Mr. Chairman.
Okay, Senator McDougal.
I think for traditional search warrants, but now we're saying may obtain a search warrant if there has reason to believe. So
Mr. Benjamin?
Shouldn't that language be, the reason to believe would have to come out if you want to use the probable cause standard, or if you just left it as search warrant without that language? But it seems to me reason to believe is more akin to a Terry type stop where you can a little more than a hunch, but not quite probable cause.
Mr. Chairman, Senator, I understand the confusion, but no, it's not necessary. It's not necessary to change that. The officer may seek a search warrant if he has reason to believe, but in order to get the search warrant, he's got to establish probable cause.
Okay.
Mr. Chairman.
Senator McDougal.
If it said that, but this says may obtain, it doesn't say seek. And so when somebody sees attain a search warrant for reason to believe, that standard is less. Mr. Chairman, this is a less than constitutional standard that we have now to get a search warrant to search somebody's person or search somebody's home.
Okay, it's been moved and seconded to report the substitute. All in favor of the motion, vote aye.
Will we be allowed to petition our government?
We've already heard the bill. All opposed, no.
Ayes 9, no 6.
Ayes 9, no 6, the motion carries. House Bill 812.
Thank you, Mr. Chairman, members of the committee.
Delegate Ward. Yeah, I'm sorry. Yeah, anything else? Okay. Yeah, Delegate Ward. Purchase of handguns, limitation of handgun, is this a 30, one handgun a month bill?
Yes, it is.
Okay, we heard that before. It's similar to Senate Bill 69, which is Senator Locke's bill. Is there any difference?
No.
Okay, all right, we've heard the bill. Is there a motion to report?
Hold on. Hold on.
Senator Peterson.
They're different.
What's the difference?
Well, we had the exception for concealed carry.
Okay, is there a motion that we,
I don't see it.
is there a substitute? Is there a substitute?
No, Mr. Chair, there's not a substitute. The substitute would be to conform it to Senate Bill 69, which is Senator Locke's bill.
Okay, all right. There's a motion that we conform it to Senate Bill 69, Senator Locke's bill that was reported from this committee 9 to 5. Is there a second to that motion? Is there a second? Motion to conform to the bill that was reported out of this committee, Senate Bill 69. Is there a motion? Been moved to conform, and it's been seconded. Is there any discussion? We've had this bill before. All in favor of the motion to yes, Senator Stanislaw.
So if you want to buy as many guns as you want, go to New York and sell them, just get a concealed weapon permit. Is that correct? Is that correct?
Mr. Chairman.
Senator Shervill.
Thank you. Speaking to the bill, yes, that's correct. And as all the concealed weapon permit holders tell us, they're the most law-abiding people on the planet. And so I'm sure they won't do that because they're law-abiding. That's what they've been telling us for 10 years.
Mr. Chair.
This is the bill that was reported out of the committee.
Mr. Chairman.
Senator Obenchain.
That is what I'm talking about. There are people in this room who view law-abiding citizens and people who hold concealed carry permits as the enemy. And that is just flat wrong.
Okay, let's not disparage anybody, please. Let's be respectful of everybody, okay? All right, it's been a motion to conform
And the award
the bill.
for best actor goes to Senator Obenchain.
Okay. All in favor of the motion to conform House Bill 813 to Senate Bill 69?
I'm not a sheriff's deputy.
All in favor of the motion, vote aye. Say aye. Aye. All opposed, no. Is there a motion to report? the Senate House Bill 812 as the substitute to House Bill 812.
Chair, you got to announce that the amendment's been granted.
The minute it's been granted, the motion has, it was adopted. Okay, we have a substitute. It's identical now to Senate Bill 69, that Senator Locke's bill that passed this committee. It was reported out of this committee and out of the Senate. All in favor of the substitute to House Bill 812, vote aye. All opposed, vote no. As 9, no 6.
Mr. Chairman.
Yeah, Senator Norman.
Mr. Chairman, I appreciate and compliment you on trying to move forward with dispatch this morning, but I hope we can maybe slow down the train just a little bit. That was a huge difference than the bill was originally presented to us, that it was in conformity with what we did, because it did not include the exception on concealed carry. And that is not a criticism of Delegate Ward at all, but we have got to be more deliberate when it is suggested that is the same thing that we previously did, and it's not even remotely close.
I believe it's
that is unacceptable.
It's a bill that we passed out of the Senate.
The second point, Mr. Chairman, is I appreciate that there is a lot of enthusiasm about these bills, but the exchange, Mr. Chairman, but the exchange that just took place between Senator Saslaw and Obenchain is unacceptable in the Senate. It is unacceptable.
Mr. Chair, Senator Norman,
Best actor
I
goes
had
to
no
Senator
idea that I had a substitute on that bill, because I would never have done that. Thank you.
It's incumbent upon everybody to be respectful of one another, and that includes senators as well as people in the audience. Okay, so House Bill 1004, Mullen. Yeah, and this is a protective orders, possession of firearms, surrender, or transfer. Yeah.
Good morning, Mr. Chair.
Same bill we did before. Yeah, go ahead.
Thank you, Mr. Chair. I believe that at this point, this bill is identical to Senate Bill 479, and I would inquire of Council if that's correct.
Mr. Chair, bills are identical now. There was a technical difference in the title between this bill and Senator Howell's bill. The bills are now identical. It was just a section symbol which was missing, but the text of the bill was all identical.
Everybody's saying we didn't vote on our bill.
Did we vote on it?
No.
Yeah, 9-6. The substitute was passed 9-6 on the previous bill. If everybody would listen instead of talking, it might be better for everybody, okay? All right, go ahead. Senator Delegate Mullen.
Thank you, Mr. Chair. Mr. Chair, this is now identical to Senate Bill 479, which passed out of this committee with a substitute 10-4.
Okay, all right. Any questions of the patron? It's identical to Senate Bill 479. Is there a motion to report the bill? It's been moved and seconded to report the bill. Senator Stewart?
Thank you, Mr. Chairman. I apologize, but I was trying to read this again. Delegate Mullen,
yes,
line 43, it says you have to certify in writing on a form provided by the Office of the Executive Secretary of the Supreme Court that the person doesn't possess any firearms anymore, or that they've been surrendered, sold, et cetera, et cetera. And it's a Class 1 misdemeanor if that's not done.
Yes, sir.
Is that, what if the clerk doesn't offer that form? Are they still guilty of a Class 1 misdemeanor? Are you putting the onus on the judge, or does the defendant have to go find that form?
Well, so there are actually a couple of other ways in which you can be able to handle this. It's not just the form. You can also certify under oath in front of the judge that you have done so. This is just making it a little bit easier on the individual. I suspect this will be just like the forms that one has to certify that they need to go to pretrial or court services after they have been before the judge, and that is the onus on the individual that they are supposed to do that, but it is part of the normal instructions that are given by a judge. The Office of the Executive Secretary sets up these things on a pretty regular basis when somebody is to be released for post-trial supervision in some sort. So I would imagine it would be just like that.
Mr. Chairman?
Senator Stewart.
I understand. The thing I'm concerned about is those other situations are not a criminal offense. And this one is a Class 1 misdemeanor, which is 12 months in jail or a $2,500 fine. So can we clarify and make sure who the burden is on?
So, Mr. Chair, may I respond?
Senator Mullen, Delegate Mullen.
It's already a violation of your probation or parole when you do that. So you're, not only are you subject to the 10-day violation of a court order, but you're also subject to revocation of the entirety of your previously suspended sentence. And so this still has the effect of a Class 1 misdemeanor and is its own other violation. And so I think if, for example, I think the example that would best be appropriate to you is if somebody has been given a DUI, for example, and part of what they are supposed to do is that they are supposed to go to VASAP within 72 hours, and they refuse to do that, they're subject to the entirety of their suspended sentence coming back.
Mr. Chairman?
Senator Stewart.
I understand, Delegate Mullen. I think you're comparing apples to oranges. My point is this is a completely new criminal offense if you don't certify on a form provided by the Executive Secretary. And my point is any other criminal offense requires a mens rea in order to be convicted. This does not. And so it seems to me if you are going to put this burden on people, you at least need to clarify in the bill how it's going to be handled, because we don't want people committing Class 1 misdemeanors without having the requisite mens rea.
Mr. Chairman?
Senator Morrissey.
I think the delegate's bill, and I would tell Senator Stewart, contemplates both situations. Number one, and correct me if I'm wrong, Delegate Mullen, but with a protective order, the 2-year protective order, there are two possibilities. The person who's being served the protective order against is either in court, at which point, after the judge issues the protective order, he is then served with that document from the Executive Secretary of the Supreme Court. Or the other option is he never appeared in court, the judge issues the 2-year protective order, and then on line 42, it says, within 48 hours after being served with a protective order. I'm assuming your bill, Delegate Mullen, contemplated him being served at his home or workplace with this protective order and being advised about the certification. Is that right?
And Mr. Chair, I think that the Senator's words are well met. I would also notice that this is requiring for a permanent protective order, you've now had multiple hearings, actual notice has been given, and so we are continuing a process of making sure that people are being served prior to them being going through this process.
Mr. Chairman.
Senator McDougal.
Mr. Chairman, and maybe y'all are reading this different than I am, and so I'm going to ask Mr. Benjamin this again. I'm reading in section C, this breaks it out. You have that hearing, the person has to transfer, they have to sell, and then there's a second piece. Within 48 hours, they have to certify in writing. There's no provision for them to provide under oath to the judge. It says if they don't certify in writing, then that's the criminal offense. So as I'm reading this, I think Senator Stewart is correct. If the form is not signed for whatever reason, they weren't given it, it's not yet produced, they ran out of paper, it's the lack of certification is going to create the criminal offense.
Okay, any further questions?
That's, I'm asking Mr. Benjamin.
Steve.
I think he's right.
I think that as written, a court would infer that the intent of the General Assembly would be that it be a willful failure. To be explicit, though, you would insert the word willfully on line 47 before the word fails.
And even if that were to take us out of this being identical to Senator Howell's bill, if it is the will of this body that be included, I certainly don't find that to be adverse.
All right, Senator Chapin moves the amendment. Is there a second?
Second.
Any discussion on this amendment? All in favor of the motion say aye. Aye. All opposed, no. Motion carries. Okay. Is there any further discussion? Been moved and seconded to report the bill as amended. We've had this discussion before. All in favor of the motion to report the bill with the amendment, vote aye. All opposed, vote no.
Ayes 9, no 6.
9 to 6. The bill with the amendment is reported.
Thank you, Mr. Chair.
Thank you. Okay, Delegate Hope, firearms and other weapons on school property. 1080. Delegate Hope, 1080.
Good morning, Mr. Chairman, members of the committee. This bill, House Bill 1080, does two things. The bill expressly clarifies that no school board may authorize or designate any person to possess a firearm on school property other than those persons expressly authorized by statute. The other thing that the bill does, it expressly clarifies that no exemption exists for a special conservative of the peace to possess a firearm or another weapon on school property.
Is this identical to the Attorney General's opinion in current law?
Yes, sir, Mr. Chairman. I brought this bill at their behest.
Okay, is there any discussion? All right, is there a motion?
Move to report it.
It's been moved and seconded to report the bill. All in favor of the motion,
Mr.
say aye.
Chairman, Mr. Chairman.
Yes, Senator.
I don't believe we had a similar bill to this, so at least the public should have the opportunity to comment on a bill that has not been seen by this committee.
Okay, all right, we'll do this. You have 1 minute each side. It's a pretty simple bill. All in favor of the bill, stand up and say aye, and say why you think it's a good bill. Don't feel like you have to.
1 minute.
1 minute aside.
Good morning, Mr. Chair, members of the committee. My name is Jessica Samuels. I'm from the Attorney General's office, and the Attorney General supports this bill. Thank you.
Okay.
Good morning, Lori Haas with the Coalition to Stop Gun Violence. We support the bill. Thank you.
Thank you.
Mr. Chairman, Andrew Goddard, Virginia Centre for Public Safety. We support the bill.
Okay.
Mr. Chairman, I've been here for 13 years and I've tried to be very respectful of everything that goes on in this room.
Thank
But
you.
I have never heard someone shout out of turn and make aspersions about someone's character, someone's intentions, or someone's motivation.
Okay,
And I
thank you.
don't respect that.
Okay, thank you very much. Okay, next. 1 minute with the people with a different view.
Philip Van Cleve, VCDL. Again, the more we restrict lawful carry of firearms in places like schools, the greater the danger is that there will be nobody there to stop an assault. We oppose.
Thank you. Next.
Ladies and gentlemen, Richard Pyle, Dinwiddie County. We protect our money with guns. We protect, in some cases, our senators with guns. We protect many things with guns. And if a locality has the money to hire someone or wants to designate someone who's a retired military veteran or a retired law enforcement officer, well-trained, well-equipped, to do that, they should be allowed to do that. Thank you.
Thank you. Next.
Patricia Webb, Hanover County. I'm a licensed FFL. I'm an NRA instructor. I'm with VCDL. Every time you restrict where people can lawfully defend themselves, you're creating advertisements to deranged killers that this is a place where they can come and create mayhem without anyone there to stop them until someone with a gun shows up. We strongly oppose this bill. The more things like this you pass, the more blood is on your hands. Thank you.
John Quapis, Chesterfield. You just passed out a law that would enable localities to do a lot more in terms of affecting gun laws, changing gun laws, restricting guns, et cetera. Now you're trying to pass a law that restricts school boards from further protecting themselves and their children in the schools there. It's hard to fathom what the real idea is behind this kind of a law, because in reality, we've seen situations where concealed carry people in no gun zone areas have actually stopped mass murder attempts by people. We are further restricting, as has been said, the ability to protect our children by doing this law. Criminals do not respect the no gun zone laws. They do not respect those signs. The terrorists do not either. The more you have responsible people armed within the school to protect the children in those events, the safer those children will be. Last, I will read to you a flyer.
But go ahead real quickly.
The flyer says, "I am a criminal. I don't buy guns at stores. I don't care about your stupid gun laws. Background checks won't stop me. Keep focusing on the good people." That's exactly what we want.
Okay.
Don't be irresponsible.
Thank you.
Stop this bill.
Time's expired. Very quickly, state your name.
Billy Haley, Essex County, and I agree with the gentleman before. That's what I was going to say was you just passed a law to let the localities do what they need to do. So why not let the localities choose how they protect their children?
Okay.
Thank you.
Okay, Delegate Hunt, to wrap it up. The statute provides for the schools to be protected.
Yes, sir, Mr. Chairman. Subsection D lays out strict criteria of who's eligible to protect schools, and that doesn't change under this bill.
Okay, fine. Is there a motion?
Move bill.
Okay, been moved and seconded to report House Bill 1080. All in favor of the motion, vote aye. All opposed, no.
Ayes 9, noes. You strike the board.
Strike the board. All right. All right, all in favor, vote aye. All opposed, no.
Ayes 9, noes 6.
9 to 6, the bill is reported.
Thank you, Mr. Chairman.
Okay, thank you. Delegate Hayes, 1083, allowing access to firearms by minors and a penalty. It's identical to Senate Bill 581 of Delegate Senator House. Isn't that right? No? Okay, there's a substitute. Okay, we got a substitute. It's been moved and seconded that the substitute be adopted. All in favor of that motion, say aye. Aye. All opposed, no. Okay. Delegate Hayes, go ahead.
Thank you, Mr. Chairman, members of the committee. Under this bill, House Bill 1083, it would be a Class 1 misdemeanor to recklessly, and that's the operative word, recklessly leave a loaded, unsecured firearm in the presence of a minor, those under the age of 14. And that has been the agreement to amend the bill.
All it does is change from Class 3 misdemeanor to Class 1 misdemeanor.
Mr.
That's
Chair,
all it does, is that right? Is that right? That's all it does?
Mr. Chair, that is exactly what it does. The law stays exactly the way it is. You just change the Class 3 misdemeanor to a Class 1 misdemeanor, and that makes it more consistent with existing law.
Okay. All right. Do we move to adopt the substitute? All right. Is there any discussion? All in favor of the motion to report the substitute on House Bill 1083, vote aye. Yeah, Senator Norton.
Mr. Chairman, this was a cataclysmic effect because as I look at the previous vote, this bill was not passed out of this committee under the Senate version of the bill.
The Senate version was defeated 7-8. Yeah, Senator Peterson.
Mr. Chair, we did have some concerns about it. I think the delegate has addressed those concerns, so I just reiterate the motion to report as amended.
Okay. All right. All it does is change the punishment from Class 3 to Class 1 misdemeanor, correct? That's all it does.
Mr. Chairman.
The existing law remains. Yes, Senator Robinson.
Well, just to remind the members of the committee, I think there were concerns that were expressed about this standard being applied differently in different parts of the state, depending upon different sensitivities. I do not believe that this is going to be applied the same way in Arlington as it is in Lee County, Virginia. And I think that poses real problems. I've heard people give speeches about us being a commonwealth, one standard for all. This bill absolutely is counterproductive in that regard. And we're talking about putting people in jail for up to a year in conjunction with this. And I think one person's recklessness is clearly another person's responsible manner of handling. I think in some parts of Virginia and some in the minds of many, maybe some in this room, simply having a gun in a house is going to be construed as being reckless. And I think in the large majority of Virginia, 95% of the landmass of Virginia, that is not the opinion that is held.
Mr.
Senator Morrissey. Senator Morrissey.
Mr. President,
Mr. Chairman.
First of all, I would say this to Senator Obenshain's remarks. We're not saying what is reckless in Arlington and what isn't reckless in Wise County. A general district court judge or circuit court judge will assess that. It is quite possible now that in two different jurisdictions, it's quite possible now that in two different jurisdictions, two different sitting judges will come up with differing opinions. That's why they'll appeal it to a court of record. Two circuit court judges could come up with different opinions. That's why you can appeal to the Court of Appeals. So this definition of reckless is not us telling every judge what to do. That judge will make that decision.
Okay. Delegate Hayes, anything else?
Mr.
Just
Chairman.
Senator Stanislaw?
Yeah, I'm not surprised by some of the opposition on this committee. 4 or 5 years ago, Senator Evan from Alexandria put in a bill to make it illegal to give a loaded gun to a 4-year-old, and it died on a party line vote. Okay. So my opposition, I'm not surprised at the opposition. They didn't even think they thought it was okay to give a loaded gun to a 4-year-old.
Okay. Is there a Senator
Mr. Chairman,
Obenshain?
I would ask what that has to do with this bill.
Nothing.
It has absolutely nothing to do with this bill. And to Senator Morrissey's point, I do recognize that, and I have a great deal of confidence in the judges of the Commonwealth of Virginia. But as everybody on this committee knows, merely being charged or being accused of a crime has the capacity to do great harm and to follow somebody for a long, long time. In this instance, we're talking about somebody who may very well have suffered a profound personal or family tragedy. And I do not believe that this is going to be something that is going to help. I mean, what we're talking about is if something horrible happens in a household, in a family, we're gonna put that parent in jail for up to 12 months. And A, I think it's mean-spirited to do that. B, I think that the prospect of just being charged with that crime is going to attach a stigma that we're just is not going to be productive. And yes, I do believe that there are, especially in light of some of the recent developments, I think there are prosecutors across Virginia who do have some very different notions about what constitutes recklessness. And I think we may see charges that really don't reflect community values.
Mr. Chair.
Senator Peterson.
Yeah, just so that everyone out in the audience understands, the law right now under 18.2-56.2 says it's already unlawful. It's a Class 1 misdemeanor to knowingly authorize a child under the age of 12 to use a firearm. Class 1 misdemeanor. Okay. What we're making is the next section up where it says it's unlawful for a person to recklessly leave a loaded firearm unsecured in such a manner as to endanger the life and limb of a child under the age of 14. We're also making that Class 1 misdemeanor. That's what we're doing. Okay, we're not banning mom or apple pie or Friday night football or anything else. We're still going to be a great nation. That's all we're doing. We're making the statute consistent. So I would call the question. Let's vote this.
Okay, all in favor of the motion, the substitute to set
Mr.
House Bill?
Chairman,
Yeah.
I've been waiting to speak.
Okay, Senator Chafin, certainly.
Yes, sir. Thank you. Mr. Chairman, I would just like to point out to the committee that it's just absolutely indisputable that we live in Virginia. There are two parallel but completely distinguishable universes. People who live in rural Virginia are not like the people who live in northern Virginia. And they enjoy differences. They enjoy consequential differences. They enjoy different lifestyles. One of those lifestyles is the sporting tradition of using firearms and teaching your children how to responsibly handle those firearms. These are the same parents that I'm talking about that are charged with birthing these children, bringing these children through life safely, driving them countless times to their ball games and everything that they like to do, all their activities. And what we're doing here is we are absolutely, every time we lay another law on the parents, we are taking away their primacy. Their primacy as parents, as responsible parents, to make decisions, responsible decisions for the future of their children. And mark my word here today, Mr. Chairman, when something bad happens, and it will, because it always does in this world, but when something bad happens and a child dies as a result of a horrible accident, that parent will be charged under this law. There will be those consequences, and there will be that rush to judgment, and that is what we are setting these parents up for. I hope that this committee will kill the deal.
Okay,
Mr. Chairman.
Senator Stanislaw?
Yeah, an observation and a question. Number one, I'd say to Senator Chafin, the law's already on the books. All this did was increase the penalty. Law's already there. It was already illegal to do that. The question I have for the delegate, are you from Northern Virginia?
No, sir, I am not from Northern Virginia.
Okay.
All right.
Mr. Chairman, if I might. Mr. Chairman.
Senator, delegate, go ahead.
I just want to say, out of these bills dealing with access to guns, and specifically in this case of child access to guns, I have worked with and around law enforcement for over 20 years. There has never been a training that I've attended or any of my colleagues have attended that did not emphasize that when you're issued your weapon, you ought to be responsible with your weapon. That is all that we're saying here, is that you need to be responsible with your weapon. That's all. To fight on behalf of individuals being reckless with their firearms, I do not think has been availed to anyone who's gone through formal training worth any salt. Anyone who carries their weapon and has gone through formal training understands that you're to be responsible with your weapon. When it comes to, and I won't use the word accidental deaths, they're unintended shootings. An individual who would leave a gun, even in the case of not necessarily, we keep pointing to a parent. What about the case where just recently, where a daycare, a person responsible for overseeing someone else's child, leaves a loaded, unsecured firearm for a 3-year-old who discharges the weapon and shoots himself? That's one example. But I can tell you, the record shows all across the Commonwealth, whether you're talking Northern Virginia, Southwest Virginia, Central Virginia, or Hampton Roads, these examples continue to happen. And all we're saying is that individuals, if you're going to carry, be responsible with your weapon. Be responsible with your weapon. Thank you, Mr. Chair.
Okay, Senator Morsi.
You know, with respect to that last comment about responsibility, in 7 years as a prosecutor, I handled 4 cases where a child picked up a gun and used it and resulted in a homicide. Never, I would say this to Senator Chafin, was there a situation where a mom or a dad who was responsible and put that gun away in a drawer or a closet was charged. In every situation, it was where one comes to mind, boyfriend of mother of slain child who was dealing narcotics, left a gun open on the table in the bedroom. A 7-year-old picked it up and literally, and I do mean literally, the little boy's name was Jaquan. Jaquan's head was blown off when 7-year-old picked that gun up. There's never been a situation that I'm aware of, Senator Chafin, where a responsible parent, I'm not saying that they had to put the gun in a safe under lock and key, but they had it secured in a closet or a drawer, was ever prosecuted. This simply says, this reasonable bill simply says that if you recklessly leave that loaded gun out there, then you can be prosecuted with a Class 1 misdemeanor. Mr. Chair, with that said, I'd like to make a motion to report.
Been moved and seconded to report the bill. We've heard this before. All in favor of the motion to report the substitute, vote aye. All opposed, vote no.
Ayes 9-6.
9-6, okay, bill's reported. Thank you.
Thank you, Mr. Chairman.
Delegate Murphy, House Bill 1288. This is a bill similar to Senator Favola's, which was continued to the 2021 session by a vote of 12-0. Okay, go ahead.
Thank you, Mr. Chairman. 1288 is a bill that addresses a number of critically important gun violence prevention issues. The list is pretty long, actually, but it brings misdemeanor domestic violence convictions into the Virginia Code. It acts as a firearms prohibitor. These are not partisan issues, they're public safety issues. I do have people here who can address your questions.
Mr. Chairman. Yeah, how does it differ from Senate Bill 490, Senator Favola's bill that was continued?
Mr. Chairman.
Let me ask the delegate first.
It's identical.
How's it, is it identical?
It's identical.
Mr. Chairman.
All right. Senator
Thank you, Mr.
Sirvella.
Chairman. Senator Sirvell. Mr. Chairman, speaking to the bill, in the last discussion we had on this bill, I think there was a major misunderstanding of what this bill does, and I've had some meetings since then with the Steve Doucette with the Commonwealth Attorneys Association, and also with the Gun Violence Coalition to Stop Gun Violence, to having a better understanding of what this bill does. And I don't think the committee quite appreciates it. So let me try and explain what this bill does. It creates a state level offense for possessing a firearm after having been convicted of a domestic violence charge. It also adds to that, by the way, stalking, sexual battery, I believe, and hate crimes. And then it creates a restoration process for people that are convicted of those crimes. The reason that's important is that because today, because of the Lautenberg Amendment, no Virginian can get their federal firearms rights restored if they're convicted of domestic violence today. After meeting with Mr. Doucette, he pointed out to me that federal law, the Lautenberg Amendment, indicates that you can actually get your federal rights restored if state law provides a remedy for you to get restored. And so by passing this statute, we would create an avenue for Virginians to get their firearms rights restored if they're convicted of domestic violence. Right now, Virginians don't have that right. And so therefore, I think there's something in this bill for everybody. And when we debated it in committee last time, everybody said you can't restore your federal rights. That's not the law, and we were misunderstood about that. We were mistaken about that.
Mr. Chair. Okay. Senator Morsi.
Delegate Murphy, would you look at line 98, which says assault and battery of a family or household member? Line 98 of your bill.
Got it.
Senator Servo referred to that as domestic violence, but that language doesn't just describe domestic violence. It also discusses or describes the situation between two brothers who get into a fight. Is there a reason that your language says assault and battery of a family or household member as opposed to someone convicted of domestic violence?
I think the issue is that we've had so many gun bills, we need to slow down.
I'm not the drafter, and so if that's a mistake, I'd be glad to have it corrected,
Mr.
but I
Chair.
don't think it is.
Senator Peterson.
I think the larger issue is this, and this is a pretty complicated bill, and there's a lot of content here. And we have dealt with a lot of gun bills this year. I mean, a lot. And just hold on one second. We've carried over the assault weapons bill, and we obviously had a lot of media about that. And I think we don't have to get everything done this year. And this is the type of bill, I know my colleague over here thinks it's pro-Second Amendment bill. I don't know if it is or not, or whether or not it's gonna make civil rights more easily restored or what. But I just feel like This is the type of bill that we carried it over on the Senate side because we felt like we had done a lot. And at some point, you just got to say, we need to hold back on a couple ideas for next year, God, believe it or not. And so I would move that we carry this bill over just like we did the previous.
Been moved and seconded to carry the bill over. Any further discussion? You have one young lady here want to say something very quickly?
Go for it.
Hi, my name is Kelly Roscom. I'm the Senior Director of Law and Policy with the Educational Fund to Stop Gun Violence. Speaking to Senator Morrissey, the reason it uses the terminology family or household member is that is the terminology we use for family or household member assault and battery. It is also the definition of family or household that we use for family abuse protective orders. It is to keep it in line with the way Virginia deals with family and household abuse. Speaking to the bill, I do think that this is a very important bill. I know we have heard a lot of gun bills this year. It doesn't make this less important. I don't think that there is any reason we should wait until next year for this very important provision. These are very serious offenses. In the year preceding an attempted femicide or femicide, 76% of victims were stalked in that year preceding that femicide. 86% of victims of attempted femicide were stalked in the year prior to that attempt. There is research that shows that violent misdemeanor firearm prohibitions reduce intimate partner violence and intimate partner homicide by up to 23%. That's a significant number of people. I think that's a very important thing to prevent intimate partner homicide. In addition, research shows that people who
You realize this is already illegal under federal law, though.
Yes, of course.
So everything you've just described is already prohibited by federal law.
Some of the things that are provided for in this bill are prohibited under federal law. This would allow state enforcement of those provisions, which I think is also a very important distinction.
Okay, Senator Morrissey.
Question for
We have a
staff.
motion. Go
If
ahead.
they would look at line 98, I understand what the speaker just said, that it tracks other law, but the language, talking about a misdemeanor conviction for assault and battery of a family or household member, would that not in fact capture two brothers who got into a fight as opposed to what the patron wanted to capture was a situation of domestic violence?
Mr. Chairman, the answer is yes.
Okay.
Thank you.
All right. We do have a motion. All in favor of the motion to carry it over for the year, which is what we did with the identical bill of Senator Favola, Senate Bill 490. All in favor of that motion to carry it over for the year, vote aye. Where's that all?
Thanks.
That's 12 noes 3.
It's 12, no 3. All right. Thank you very much, Delegate Murphy. All right, now we move on. I think we finished the gun bills. Is that right? We've done 9 bills in an hour. I don't think there are any more gun bills. Is that correct? Yes, that is correct. Okay, no more gun bills. All right. We move on to Block 3, which is uncontested identical bills. House Bill 1300, Delegate Hurst. I don't think we need him. It's identical to Senator Norman's. Senate Bill 607 has to do with the statute of limitations on performance bonds, et cetera, government construction contracts. Is there a motion to report House Bill 1300? It's been moved and then seconded to report House Bill 1300. All in favor of the motion, vote aye. Aye. All opposed, no. All right, no sidebars. We got, the clerk has got to report. 15-0. The motion carries. No more sidebars, please. All right. Block 3, contested identical bills. Okay, I've talked to Delegate Hodges, House Bill 1271, and he's prepared for us to take the bill up. It's identical to Senator Lewis's Senate Bill 792. It has this conveyance of right-of-way usage to certain non-public service companies. Is there a motion that we report the bill? It's been moved and seconded that House Bill 1271 of Delegate Hodges be reported. All in favor of the motion, vote aye. All opposed, no.
Ayes 13, no 0, 2 abstentions.
13-0, the motion, the bill is reported. All right, Delegate Lethwich, House Bill 1391, Deeds of Trust, Fiduciary Duties, identical to Delegate Chafin's. Senate Bill 1253, which is reported out of this committee 8-5-1. And
I move we PBI.
it's been moved and seconded. Is Delegate Lethwich here? He's entitled to speak.
He left, he was here.
He was here. Does he want us to carry it? Wait till he gets back? Okay, well, we'll wait till he gets back, give him the privilege.
I believe you killed rattlesnakes
All
when they're
right,
small.
Delegate Lethwich bill will be carried over temporarily. Block 4, regular agenda. All right, Delegate Mullins, you have, is he still here? Having to do cruelty to children? That's not the same as one we had before? Huh?
He's not here.
No, he left.
Yeah, we passed it by last Wednesday. All right, Delegate Mullins is not here. Yeah, we'll do that. All right, well, I got Delegate Lethwich. He's not here. Simon, Hodges, Bourne. Okay. All right, I'm just going down the list. Collins, Mullen, okay. Delegate Watts. Everybody wants you. Delegate Watts. Protective orders.
Thank you.
House Bill 1182.
Thank you, Mr. Chairman. 1182 is before you because as you look at the code and the list of specific things that may be included in any one of the conditions of a case of family abuse, you will see that they are very specific. It's a Christmas tree that has been very specific about whether it's the residence, whether it's utility service, whether it's a cellular telephone number. Therefore, the bill before you on lines 40 on condition 10 talks about, the amended bill before you talks about financial assistance for the protection or well-being of the family so that the financial assistance can be applied more broadly without having to be tied to one of the specifics of the Christmas tree list above it.
Any questions? Senator Boyce? No, okay, Senator Deeds.
I would just ask counsel, on line 41, is well-being refer back to financial, or what does it mean, well-being?
Mr. Chairman, I'm not sure. It's not used elsewhere in this section. I don't believe that would be a new term.
Okay, any further? I have a question, Senator Delegate Watts. It seems to me what you're doing here is if there's, anytime there's a protective order, the court may also issue spousal support. Aren't the two different? I mean, the protective order, then you have a spousal support. It's nothing automatic about spousal support just because you have a protective order, is there?
The problem is that the list above it is so specific on specific elements of financial support that I don't believe the example of child support is in fact listed there. So that rather than adding a Christmas tree that specifically says child support, since this was something that was brought into question, instead by taking the line, any other relief necessary for the protection of the petitioner, saying the protection or well-being, so that it makes that same sort of broad statement that what the protective order should address is not just the safety, but also, again, well-being, which would be financial.
Mr. Chair.
First of all, Senator Stewart here.
Thank you, Mr. Chairman. Delegate Watts, is there anything that prevents a petitioner from filing a motion for temporary spousal support without putting it in a protective order bill?
The bill was brought to me by the Property Law Center, and I know they were running into problems because of the specificity of the list of having that question. And
Mr. Chairman,
they're in the room.
Mr. Chairman.
Senator Stewart.
But is there anything anything that prevents a petitioner from filing a petition for temporary spousal support aside from getting a protective order? Can't they do both and run it on a dual track?
As I understand the challenges that have been made to this particular statute, there have been challenges made because it's not specifically laid out when other elements of financial support have been specifically laid out. And so this gives a context for things such as child support to be in the order.
Mr. Chairman. Yeah, Senator McDougal.
This is for Servo down there. Is spousal support traditionally decided in JDR or circuit court?
Circuit Court.
Mr. Chairman.
Mr. Chairman, I would just say, I think you can seek separate maintenance in juvenile court, but 97% of the cases are done in circuit.
Mr. Chairman, that would be.
Senator McDougal, go through the chair.
Mr. Chairman, that would be my concern about spousal support. Child support is a different issue because juvenile and domestic relations district courts traditionally do child support, but they do not traditionally do spousal support. That is typically reserved for circuit court in a pendente lite or equitable distribution process.
Mr. Chairman.
Just finish one at a time. Finish up, Senator McDougal.
I thought he was wrapping up,
Okay.
Mr. Chairman.
You finish? Okay. Senator Searle.
But the other difference is that child support is a formula, and there's a guideline that's presumptive, whereas with spousal support, in some jurisdictions, there's a formula, and some there isn't. I think Delegate Collins might have a bill later on the docket about that, but anyway, they're different.
Mr. Chair,
Senator Deeds.
it worries me, this phrase well-being, because I don't know where else it appears, and I wonder if you just strike the word financial or on line 41 and change our well-being to or support and maintenance. Because we know what that means. I'm not sure what well-being means. I'm not sure the courts are going to know what it means.
Any explanation? Go ahead.
Sushila
Poverty Law
Varghese
Center, yeah.
from Virginia Poverty Law Center. Mr. Chair, so Senator Deeds, are you saying to replace or well-being with the
What I'm
language?
saying is strike financial or, so any other relief for the protection or support and maintenance of the petitioner and family, et cetera. That makes it very clear that what you're talking about is financial, because that's what Senator Delegate Watts said she was interested in, financial. That's what well-being refers to, financial well-being. So if we made it straight, clear, support and maintenance, that's what we all know as practitioners and what courts recognize.
So I hear what you're saying. Part of the reason this was brought is that there is a section that describes child support. There is no section that describes spousal support or other financial relief. And some judges feel that they cannot issue that if it's not listed as an enumerated provision of relief. Also, most of these types of protective orders, even 2-year protective orders, we're talking about pro se litigants.
Mr. Chair, I just wonder, but do you think the amendment I've suggested solves your problem?
So can you just say it one more? So it would be any?
It would read any other relief for the protection or support and maintenance of the petitioner and family or household members.
Yeah, I think that would work.
All right, for the protection, say that again, any strikeout financial, or line 41, any other relief, strikeout financial, or any other relief necessary for protection, and what else? And support and maintenance?
Support and maintenance instead of well-being.
And support and maintenance of the petitioner. And family and household members of the petitioner, et cetera. Is that the motion?
I think if that's all.
Does staff have that? Okay, all right, so we strike out financial or in line 41, so it reads any other relief necessary for the protection and support and maintenance of the petitioner.
And then, Mr. Chair,
And
once we
strike out
make that
or
amendment, we
well-being.
can get to whether this bill's really needed or not. But it just seems to me that says it a little more clearly.
Right, is that clear? Did everybody understand the motion?
Yeah, Mr. Chair.
Senator Peterson.
I think the problem is that children are different. And the reason why children are articulated and enumerated, first of all, because they're not in the middle of this action. You may have a husband and a wife that are obviously at odds, which is why you have a protective order. But regardless, we have to take care of the children. Alimony is a little bit different. And hold on, ma'am, I'm not in ask for a response. I will get to you in a question, but you recognize that the reason why child support is in the order is because the children are not the petitioner or the respondent. They are innocent third parties. And what you're doing here is saying a party who actually filed the petition, whether it's the husband or wife, is also allowed to seek their own financial well-being, which is a different, qualitatively different aspect than protecting the children. Do you see that?
Mr. Chair, Senator Peterson, part of the reason I asked for Delegate Watts to bring this bill is for restitution, property damage, those types of financial making whole of a victim, okay? So spousal support is a part of support that certain victims are going to need. And the way it is written before the suggested amendment by Senator Deeds is that if spousal support is issued through a protective order, it shall terminate upon termination of spousal support elsewhere, right? As Senator Serville was talking about, it's normally done in circuit court. So if you want to change the bill as Senator Deeds described, I think you're going to still need this provision about spousal support, because it's not just about support of the abused party. It's about making her whole with other types of financial
Ma'am,
support.
first of all,
Senator Peterson.
first of all, both sides make allegations, so don't always assume it's the woman that's making the allegations.
I understand that.
Okay?
Legal aid represents many men
Yes,
against
ma'am.
against
Secondly,
abusive women.
understand it's an allegation, and it may or may not be true, but the point is that it's the petitioner and the respondent. It's not about their well-being, it's about the children's well-being. And my objection to this bill is that you're now trying to bring one of the parties in and giving their financial interest in the case when they already have a separate remedy to recover that.
But a protective order is partly important for support for the victim too. And that may be part of the emergency relief that she is going to need, he or she is going to need, let's say, a victim who has not worked ever, and this is a 20-year marriage, and they're seeking a protective order. This is at the 2-year stage, right? The full protective order stage. This is an opportunity, and frankly, some judges do issue, the any other relief provision, they do issue this, but it sometimes is not happening because, as Delegate Watts described, we have enumerated many specific provisions.
Ma'am, you understand there's a pendenti lite, I mean, there's a whole method, a whole avenue of pendenti lite support. I mean, we have a whole.
I understand that.
This is for the protective orders, to protect people physically.
I understand that. And I do think the financial relief is tied to a victim's safety.
John,
Senator Morrissey.
I like the spirit of Delegate Watts' bill, and I very well may support it, but let me just ask you this. With the amendment that we made on line 41.
We haven't made it yet.
Well, with amendment we're discussing.
We're discussing it.
On line 41, doesn't, particularly the language family or household members, doesn't that contemplate what you want to do beginning in line 48? We all agree that there's got to be, some provision has got to be made for the children beginning on line 44. You want to add the temporary spousal support beginning in line 48. I get it. My question is, with the proposed amendment on line 41, don't we do that?
I believe so, and I said that I believe so. So it was, I think
Senator Peterson does not like the language in line 48. Would you be willing to redact that language, knowing that if in fact we amend line 41 et sec?
Yes.
Okay, we got a motion before us. Senator Deeds.
Mr. Chair, I'd like to amend the motion then, and I would strike the new language from lines 48 through 47. Or through 51,
47
I apologize.
through 50.
48 through 51. 48 through 51, and
then
making the line amendment on line
Strike
41.
financial and then or support and maintenance.
Okay.
Instead of or well-being.
Yeah. Line 44, 41, delete financial delete or well-being, and add after where or well-being was, or support and maintenance.
and then strike lines 48 through 51.
Yeah, yes, that's right, all right.
I'd be fine with
Is there a
that.
second to that motion?
Second.
Okay, is there any further discussion? All in favor of the motion, say aye.
Aye.
All opposed, no. All right, the motion is made, and is any discussion, any further discussion?
Mr. Chairman.
Senator Sturgill.
Sorry, I'm still just not clear what the point of this is because, you know, protective order proceedings have enough issues as is right now, and I've litigated them on both sides. But at least in the jurisdictions that I practice in, if you need to get in the court to get alimony, you can get in there within 2 to 4 weeks. And these protective order proceedings, typically the focus is the incident that resulted in the protective order. And now you're gonna have to come and tell your client, bring your tax returns, bring all these documents to fight of alimony. These hearings sometimes take 30 or 45 minutes. You barely have enough time right now as it is to focus on the assault allegations. Now we're gonna broaden it up to a full-blown divorce pending light proceeding encapsulated in some minor tiny proceeding in a court not a record. I have a hard enough time defending these things or prosecuting them, and I just have to come with all the financials now to do that. It's just, I'm not clear how workable this is when you have a remedy in circuit court already for the same thing. So it's just not clear to me that this is a solution to whatever problem it is we're trying to address. So I have concerns about either way, even with the amendments.
Senator Stewart.
Thank you, Mr. Chairman. And Mr. Chairman, I share the same concerns because the protective order process is a process that a petitioner can get into pretty quickly to get help that I believe they need. And now if we convolute it with this, I don't know when they're going to be able to get in to get that if they try to seek this. Plus, I'm very concerned that it would encourage people to file for a protective order when they may not otherwise file for a protective order because you get dual remedies under this track. And the two-track remedy that we've had ever since I can remember, I think works. And I think this really convolutes the process and not in a good way.
Okay. All right. Anything else? Is there a motion to report the bill as amended? It's been moved and seconded to report the bill as amended. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 6, noes 9.
Ayes 6, noes 9. Okay, thank you very much, Delia Watts.
Thank you for the dialogue.
Okay. Okay, now we're going to go down the list. Where were we before? The left, which I believe was, is he here? All right. Yeah, there he is. Yeah, Delia Leftwich. You got it's House Bill 1391. There's a motion already to PBI. All right, speak for the bill. It's identical to Chafin's Senate Bill 253. Deeds of trust, fiduciary duties. Some people like it, some people don't.
All right, there is an amendment in nature of a substitute.
Are the witnesses here on this bill? No.
I don't believe so. Well,
Okay,
yeah.
okay, all right.
If you call them a witness.
Call a witness. All right, go ahead. Explain why this is a good bill. Some of us don't like it.
Okay, so.
You got a substitute? What's this? All right, is there a motion
First,
to adopt the substitute?
I'll explain what the substitute adds some language to 55.1-322, which are notice provisions. I think there was some concern about an owner of a property not having the opportunity to protect their rights, and hopefully the notice provisions
Okay, is there a motion to
address
adopt the
those.
substitute? Is there a motion, Senator Chapin, to adopt the substitute? All right, is there a second? All in favor of the motion to adopt the substitute, say aye. Aye, all opposed, no. The substitute's adopted. Okay. Explain how this makes life better in the Western world.
Okay, so I won't go into great detail about the initial bill, because I believe this committee has heard that. Senator Chafin carried it on the Senate side. The amendment, I believe, makes it better in that it gives, so I think the concern with the original bill was that you'd have very few people show up and bid on the property, which might drive the price down and lend itself to an owner of the foreclosed property not the price not bringing the highest and best value, and which, if it didn't, would shortchange the owner. The notice provisions are intended to allow it be disseminated to a greater number of people and hopefully facilitate more interest in the actual foreclosure sale, and therefore drive the price higher and add more protections to the owner in the event of a foreclosure. Does that make sense?
I guess, anybody have any questions?
Mr.
Yeah,
Chair.
Senator Chafin, Senator Peterson.
Okay. Delegate, we had a very long hearing on this, and let me say, I appreciate your substitute, but it really does nothing, to be blunt, because what you're saying is he has a fiduciary duty, the trustee that is, but he complies with the fiduciary duty as long as he fulfills the terms of the deed of trust, which is circular reasoning. I mean, basically takes us right back to start. And the problem is, and I've talked about this with other senators, we have a Supreme Court case on point which says that a trustee in a foreclosure has the common law fiduciary duties, which are the duty of due process, the duty of fairness, the duty of impartiality, being accessible both to the debtor and creditor. In other words, if the debtor calls you, you return his phone calls. Just like if the creditor calls you, you return his phone calls. Reading the actual note and accurately calculating the amount due, not just taking an affidavit from the creditor and assuming that it's true. And I've had cases directly on point. I've got one I'm going to argue in front of the Virginia Supreme Court in a couple months. And to me, the Supreme Court has been correct in saying there is a common law fiduciary duty beyond just the bare bones that's stated in the deed of trust. So I recognize you're trying to reach out here, but I'm still pretty hard no on this.
Okay, thank you.
Whatever that's worth. That's not a question, but a statement. I apologize.
Any other questions? Let me tell the delegate, I had a case, and I told the Senate on the floor back in, I think, 1987, show you how old I am, I think from Carroll County. And a substitute deed of trust trustee, who was also the principal of the lender, bid the property in for her own company. Supreme Court was upheld by that was what the trial court upheld that. And the Supreme Court reversed because of fiduciary duties. It's a clear conflict of interest. A trustee cannot buy at his or her own sale. As a trustee has a duty to be fair to both parties and cannot buy the property. And that was a clear-cut case. The senator from James City County talked about commissioners of accounts being like a stopgap, but I don't think that's true everywhere about long shot. In fact, typically what happens is sometimes if the property's sold for undervalue, people go to court and have some judge stop it. And I've seen that happen too, at least in my area. So I think it's a bad bill.
Mr. Chairman.
Yeah, Senator Norman.
I'll spare you the loquaciousness, but Commissioner of Accounts have been reminded that they have a joint fiduciary responsibility to both the debtor and the mortgage holder, and that one is not entitled to preference over the other on it. And you heard me when I rambled on the floor that I have consistently rejected foreclosure sales where it is conspicuous that there has been a de minimis value that has been bidded in regardless of the affiliation of the individual that has purchased it, and the courts, at least in my area, have consistently sustained it.
Okay, Senator Stewart.
Mr. Chairman, the thing that disturbs me, no offense, Delegate Lefwich, I didn't like the Senate version of this. This bill is designed to limit remedies to somebody that's losing a piece of property. And why would we do that? We have hundreds of years of common law that the Supreme Court has interpreted that governs the sale of these properties and the trustee's obligations. And this bill does nothing more than limit the remedies of those folks who are losing the properties and expands, in my opinion, immunity for trustees. So I'd move that the bill be passed by indefinitely.
Second. Yes, substitute motion. I wonder what that is. Okay. First, is there a second to the substitute motion? Okay, it's moved and second to the substitute motion to report the bill. Senator Chafin.
Speaking of that motion, Mr. Chairman, so Delegate Leftwich has crafted a very careful amendment substitute to this to the bill that got out of the Senate, and it improves the bill. It gives additional assurances for advertisement, which inures to the benefit of the debtor. It bolsters the bill. But what this bill is all about, it recognizes that there are fiduciary duties to both the debtor and the creditor. The bill recognizes that. The existing law recognizes that. It just simply says that when there is a conflict in those fiduciary duties, if the trustee has complied with existing law and with the terms of the deed of trust, the trustee has done what he or she is supposed to do. And that is what the bill is all about. It gives some degree of finality to the execution of these unfortunate situations when there is an execution of a deed of trust and a property must be sold in order to enforce the obligations of the debtor.
Okay, Senator Morrissey.
To the patron, or if you can answer this question, and if you can, I'm sure somebody on this panel can. I've struggled over this bill. I've looked at all the different iterations, but I want to get it right. And if I do that, then I'm okay with my conscience. But with that said, look at page 3, line 56. A trustee has no duties, rights, etc. Doesn't that just state the obvious? I'm not being cheeky, but that's not new law. That just states the obvious, correct?
I believe so.
All right. Down to line 71. Just states the obvious. Doesn't do anything, right?
I believe so.
The crux of your bill, is it not, begins on line 99 at SEC, where it talks about the duty to advertise and get it out there. Is that right?
Yes.
All right. So here's my final question. Isn't this going on all the time? Houses are foreclosed upon. There's a cadre of people up at the courthouse that are hoping to get a bargain.
I believe that's correct.
They get that bargain if they can buy that house significantly undervalued. It seems to me the only thing that we need to do, and maybe I can be corrected, but is make sure that everybody out there has the opportunity to see what this property is being sold at, so that they can avail themselves of a bargain or not. Am I right?
That's part, yes.
Okay. If I am missing anything,
You're missing
Senator. Okay.
I'm missing people that say you're missing a lot. Go ahead.
Then I know that I'll be corrected by Senator Peterson, who does this for a living, and I'll also be corrected by Senator Normand.
Okay, Senator Robinson.
Mr. Chairman, Senator Morrissey, what this bill does, as it was described to me by the Senate patron and by others who support this bill, is it overturns the Crosby case, which was decided by the Virginia Supreme Court, I guess, just last year. What the Crosby case dealt with was a pretty egregious set of circumstances. This property owner took out a $60,000 loan and secured it with a deed of trust on a home that was assessed by local government at $436,000. The property owner was in rehabilitation, out of contact, and did not receive notices. He received a notice of foreclosure 2 weeks before a foreclosure sale. My understanding is, contacted the trustee and said, at that point, owed $20,000. $20,000, actually less than $20,000, $18,000, said, I want to buy it back. I didn't get these notices. I want to pay it off. The sale went forward. Nonetheless, there were two potential bidders who decided we're going to combine efforts, and they bought the house at foreclosure for $21,000. The property owner had to file suit, and the Supreme Court, citing common law fiduciary duties, held in favor of the property owner. You know, I do understand what the patron and the Senate patron and the bankers are trying to address. I'm not entirely satisfied with the outcome of the Crosby case. However, I'm also not entirely satisfied with this bill because it would take away from the courts the ability to have any kind of say over the adequacy of the consideration. I mean, this guy lost his $450,000 house over his offer to buy it or to buy it back for $20,000. You know, there are a lot of trustees out there who do a really good job, and I used to have a couple of law partners who went to great lengths to make sure that sales were well attended, that the bids were fair to the bank and to the property owners. But there are also some trustees out there who, and you see it in the newspaper, where they put in 20 different property listings, no website, no pictures, no open house, no nothing. And, you know, it's just for some, and I think they're, you know, the exception to the rule, but for some, they are, you know, it's a mill. And I think that it's important to have some standards. I don't think that the status quo is optimal, but I don't think the status quo ante is either. And I think that, or that this bill is an optimal solution either. And I think there's a solution, but we haven't seen it. This is unfair, I think, to property owners.
Senator, Delegate, are there people here to speak for the bill?
Can we take some testimony?
Or against the bill?
Before we debate it?
Is anybody here for or against the bill?
I think we have someone for.
Everybody for the bill, first stand up. If there is anybody there.
Mr. Chairman, members of the committee, Matt Breen with the Virginia
I tell you
Bankers
what,
Association.
Let's do this, if we can, let's make it 3 minutes aside, because I think it's an important bill. Go ahead.
I mean, I'll be brief, Mr. Chairman. You heard the testimony on Senator Chafin's bill and now from Delegate Leftwich. I think what we're trying to do is get some clarity and finality.
Let's cut back on the sidebars, please. Go ahead.
We're trying to bring clarity and finality to the process. We think there was some ambiguity that was put in by the court in the Crosby decision in December of 18. I think what we've used as our guide is Justice Mims and Goodwin's dissent in that case. I think this tightens it up to what we need to be. Open, the bill's been here for a while, to what other options are. We think the Crosby case went too far. We believe that this gives, again, the clarity that we're seeking, and we hope you support the bill.
Anybody else in favor? In favor. All right. All opposed, 3 minutes. Got a bunch of people there.
Jay Spear with the Virginia Poverty Law Center. And to Senator Morrissey's question, this does not state what current law is, because what it says is that fiduciary duty, it acknowledges the fiduciary duty, but then it goes right after that, it says that there is no breach of that duty as long as you follow the deed of trust in the statute. The fiduciary duty is not in the statutory law, it's not in the deed of trust, it's in common law, and if you pass this bill, you will be changing that.
Person.
Hello, Mariah Williams from Housing Opportunities Made Equal. One of the things that we do as an organization is we run a foreclosure prevention program, and we're here to oppose the bill. Reason being, there have been a number of instances where one of our clients' homes has gone into foreclosure. We've sent over the necessary documents to stop that foreclosure, only to be met with, we haven't received those documents. The only thing that has helped is being able to pick up the phone and call the trustee to essentially help that client stay in their home. And so with that, we definitely do not support this bill. Thank you.
Thank you. Next.
Michael Morgan, Chesterfield County. This bill will absolutely impact the minorities in our community. My home was actually foreclosed on unlawfully in 2015, and I'm a hardworking individual who works in nonprofits. And with this bill passing, I would have lost my home. If it wasn't for the help of Virginia Poverty Law Center and some other people, I would have lost my home and everything that I had.
Okay, thank you. Next.
Hello, Christy Kelly. I'm on the National Consumer Law Center Partners Council and the Board of Directors of the National Association of Consumer Advocates. What this bill does is it overturns 100 years of common law. The advertising issue is a complete red herring because what it does is it would prevent the duty of impartiality. And so when what Senator Stewart said is correct, and Senator Chapin, with all due respect, if there's a dispute between the fiduciary duties, the fiduciary has a duty to petition the court for aid and direction on the right course of action to take, because you're taking away someone's home. Right now in Virginia, we have one of the fastest foreclosure timelines in the nation. And you have more rights as a tenant squatting in a property than you do as a homeowner. And if this bill passes, you are taking away every protection a homeowner has. I do this type of work, and I do it on a contingent basis, not as a fee-generating type of work. And I see people every week who have payment disputes with their mortgage servicer whose home's in foreclosure, and they don't maybe have the money to bring it all current to get it worked out prior to that 14-day notice of sale. But with the fiduciary duty, many of the trustees in this Commonwealth do the right thing, and there's never an issue. And I understand this is to address the Crosby case, but Crosby happened at the end of 2018. Name one thing that has happened as a result of Crosby that has caused turmoil in the Commonwealth. Nothing. I have done dozens of cases in the past year that without the fiduciary duty under common law, the people would have lost their homes who didn't deserve to lose their homes, who pay their bills and pay their mortgages. And to pass this bill would erode property rights and hurt homeowners in this Commonwealth. Thank you.
Thank you very much.
I have a question, Mr.
Okay,
Chairman, of this young
yeah,
lady.
Senator Norman, got a question.
I respect what you say, and I disagree with some of your points, but you just made the assertion that I appreciate the good people and they're paying their bills. If they're paying the bills, why is the home in foreclosure?
Because there's an issue where the check went to the mortgage company and it went to the wrong account. And it takes 30 days under federal law to even get a response to your letter. And by that time, a foreclosure occurs. And so what we do is we contact the foreclosure trustee, we give them the proof of payment, the letter, and they're like, I can't go forward with this, and they don't foreclose.
Mr. Chairman, have you ever seen a foreclosure that was started when there was a 30-day arrearage? Ever?
Not a 30-day arrearage, but I have seen foreclosures where people have reinstated, and there could be money tied up in bank accounts, wires because of OFAC rules, and a foreclosure occurs anyways. There are so many instances where one bad day and you're behind 30 days. It shouldn't mean that you lose your home. It shouldn't mean that a tenant has more rights than a homeowner. Many people's sole wealth is the equity in their homes and everything they put into their homes where they raise their families. And we're going to take that away. 100 years of common law, and there's not one instance since Crosby that has been pointed to say why this needs to change now. Thank you.
Thank you very much. Okay, anybody else have any questions?
If I could get the last word.
Yeah, you get the last word. Wrap it up.
So the problem with majority opinion in Crosby is it's placing a trustee in a position to call balls and strikes. This is not enough money. This is too little money. And so if you are a lender who's loaned money under an agreement for repayment, and you have a trustee that's saying, I'm sorry, we had the auction, but we can't let the sale go through because it didn't bring enough money. And so I'm the lender. I'm out of pocket for a couple $100,000. How long do I have to wait until someone comes and bids on the property sufficient to satisfy the trustee? I haven't looked at the exact date this case, this fact pattern occurred, but if it occurred, for example, 2007, 2008, 2009, when the market's down, how long can a trustee make a lender wait to get their money? And so you've got a trustee who has a fiduciary duty under common law, and I think under this bill has a fiduciary duty, The place to determine whether there's sufficient value at the sale is with a Commissioner of Accounts who's appointed by the court to review these things. And so I think we're left with a policy decision. I think it's purely what this boils down to. And that policy decision is, as someone who negotiates at arm's length to borrow money against someone who is lending money, what rules apply if there's a delinquency? And that contract should control. If there's a dispute as to whether that has occurred, then that belongs with the court and the Commissioner of Accounts and other remedies that the person may have.
How do you explain?
Mr. Chair, I have a motion.
I have a question.
Mr. Chair, I have a
I think there's already.
I have a question to the
Yes, sir.
patron.
I have a motion.
How do you explain, just, please, no sidebars. A house valued, fair market value of $436,000 being sold at a foreclosure for $21,000. How do you explain that?
So I think you explained that because there was a down market and there wasn't interest in buying. No one had money. No one was buying real estate.
In 2018?
Down market in 2018.
There was a down market in 08, I understand, but in 2018?
So, I also believe that in that fact pattern, there were other remedies that would be available to the homeowner in that situation.
All right, okay. All right, there's a motion to, what's the motion? To pass it? PBI? No, the motion is to report the bill.
Make a substitute.
No, that is the substitute motion. All in favor of the motion to report the bill, vote aye. All opposed, vote no.
Ayes 3, noes 12.
I think it was defeated.
Yes.
3-12, I think. Okay, is there another motion to pass by? Original motion was to pass it by indefinitely. All in favor of the motion to pass it by indefinitely, vote aye. Vote aye, all opposed, vote no. Okay.
Ayes 13, noes 2.
Ayes 13, vote noes 2. Thank you, Delegate Lethwich. We
Yeah,
appreciate your
I think I have
being
some
here.
other bills.
Yeah, you do
here.
have several other bills, 3 other bills. 1359, jurisdiction of civil claims, amending amount of claim. House Bill 1359.
So hopefully this bill is a little bit less controversial. So essentially, if you're in a circuit court and you amend your claim to a value consistent with the general district court, you can transfer the case rather than having a non-suit and refile. Did the same thing last year as it relates to civil matters in general district court going to circuit court, and this just adds circuit court provision.
Okay.
I'm not sure whether there was a companion bill for this in the Senate or not.
It's not the
No.
the piggyback bill that I had. Okay. All right, is there a motion? Is there anybody want to speak in favor of the bill? All right, speak briefly in favor of the bill. Okay.
Mr. Chairman, Mark Dix on behalf of the Virginia Trial Lawyers Association. We appreciate Delegate Leftwich bringing and we support the bill. Thank you.
Okay. Thank you. And you want to explain it, anybody against the bill? Okay. Where did this come from? Did it come from a Boyd Grace conference or?
No,
okay.
this was,
Your idea?
I don't know where it came from. The VTLA brought it to me. Last year I
VTLA.
carried it. It may have been a Boyd Graves
trial
bill
lawyers, okay.
last year that this is
Is
clean
there a
up.
motion to?
Mr. Chair?
Yeah, Senator Warsi.
Let me make sure I understand this right. Again, just trying to be educated about
Yes.
it. This bill, the matter is in circuit court, and the person is suing for $50,000. The plaintiff says, I want to, who brought the suit, I want to lower it, I move to lower the amount sued for to within the jurisdictional limit for general district court, say $25,000, and then the court then will remove it to general district court. Where if either party doesn't like the result, they can end up appealing again to circuit court. Is that right?
They could, yes, sir.
Okay.
Is this controversial?
I don't think any, not that I'm aware of. Okay, a move has been made and seconded to report the bill. All in favor of the motion, vote aye. All opposed, no.
You were being funny.
Ayes 15, no 0.
You've had a reversal of fortune. 15-0, the motion carries. Okay, the next bill, let's see here. 1380.
Okay. Mr. Chairman, this is the Uniform Directed Trust Act. There is someone here who can speak to this more informatively than I can, but essentially, you've got a movement in the arena of trusts to have directed trust, and the director serves in a little bit different capacity as, say, a trustee. And so Virginia doesn't have any clear set of rules that governs a directed trust. And so this adopts the Uniform Act on directed trust so that those rules can be in place in Virginia. But there have been some areas of it that are tailored more specifically to the Virginia way, if I will.
Okay.
Mr. Chair, I would just appreciate understanding the difference between trustee and director of a trust.
So, and we have a speaker here, but so from my understanding, a trustee has all of these various fiduciary duties, and they can only do what powers are granted to them. A director, I would analogize to like a director that sits on a corporation, on a board, and they have very specific responsibilities are spelled out in the trust.
But, Mr. Chair, are we setting up some kind of conflict between a director? If a director's got one view of the way a trust is to be managed and a trustee has a different view, who decides?
I don't believe so, because the director's roles are very specific.
Okay.
And a trustee is broader.
Okay. Okay. Your name?
Good morning, Mr. Chairman, members of the committee. My name is David Kamer. I'm a trust and estates attorney with the law firm of Kaufman and Knowles in Norfolk. And I'm here on behalf of the legislative committee of the VBA's Wills, Trusts, and Estates section. So the proposed bill is based on a Uniform Act that was adopted by the Uniform Laws Commission and passed by 10 other states. It clarifies who has primary fiduciary responsibility when someone other than a trustee, a so-called trust director, has a power over an aspect of a trust's administration, typically a power to direct the trustee to take or not take certain actions. Legislation would place that fiduciary responsibility squarely on the shoulders of the trust director with respect to the given power. The proposed legislation also contains a number of practical administrative provisions, filling in gaps that are present in our current statute. And overall, it's clearer and more comprehensive than our current statute. And it's consistent with the expectations of most settlors, directed trustees,
Mr. Chair,
and trust directors. Yes.
Senator Dees.
And it's difficult to comprehend all this new language in a few minutes, but this assumes that the trust names a director with powers separate from a trustee.
That's, Mr. Chairman, yes, the trust terms would contain provisions that grant the trust director specific powers.
Well, Mr. Chair,
Okay, Senator Dees.
so to this point, there have been no trusts drawn in Virginia that name directors separate from a trustee?
Mr. Chair, those trusts do currently exist.
Okay.
The issue is that our current statute is not clear in where the fiduciary responsibility should lie when you have a trust director. It can cause the directed trustee to have fiduciary responsibility for following the directions of the trust director.
Mr. Chairman?
Yeah, Senator Obenchain.
Can you help me just understand practically why somebody would do this, create such a trust director?
Sorry.
I mean, just give me a practical example.
Mr. Chair, so sometimes you see this where someone names a trustee to generally administer the trust, but they want someone else to oversee the investments of the trust and to make directions over whether to buy or sell assets, or sometimes there can be a trust that holds a business, and they want a specific person with that type of experience and knowledge to oversee the manager of the business, and that person direct actions with respect to the business, but they don't want, the settlor does not want that person to serve as trustee of the overall trust.
Mr. Chairman?
Yeah, Senator Obenchain.
I mean, can't a trustee under current law do that? Why would, I'm just having a difficult time understanding why you would create this new level.
Senator Shane, so I don't represent the trust, but I represent an individual who has an ownership interest in a business that is governed by a trust. And so this is like 3 businesses that an owner left in trust for the benefit of their heirs. And it's multi-million dollar enterprise. And so the trust directors are charged with running the business, making the decisions on whether to open up a facility in Atlanta, whether to stay just in Norfolk, negotiating contracts for the sale of the products that they are manufacture and distribute. And that's totally different than what the trustee would do in order to spend the money for the benefit of the beneficiaries. And so clearly the directors has to have a business acumen that, say, someone else may not have in terms of deciding how much money they're going to spend on educational opportunities, or they go to a soccer camp during the summer, whether they need a new Camaro or whether a Honda, Accord is a more appropriate vehicle. And so the need for that dichotomy of experience and knowledge to manage large estates with big business interests. I don't think you'll see this in my estate, for example. But for those that are larger and more complicated, it is a useful tool. And this bill, what this does is it creates a mechanism to govern those responsibilities. We just talked about a bill where there was hundreds of years of law that tell us what you do and don't do in these situations. This bill overlays on top of what people are doing so that there is some certainty as to what their rights and responsibilities are in that environment.
Mr. Chair.
Yeah, Senator Deeds.
The language on lines 198 and 199 don't have anything to do with the appointment of a director. Is that new law?
That is not new law, Mr. Chair. That actually, a couple of things. One, it appears in our current statute. It's just moved to a different location. And 2, it's based on settled trust law, which is where you have a revocable trust and the settlor has the power to completely take the trust property back. The settlor is not treated as a fiduciary, so it would be unfair to treat the trust director as a fiduciary for following the directions of the trustee. But that is not a change to the current law.
Okay, anybody who wants to speak against this bill? Okay, is there a motion? Motion is made to report the good bill. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 11, noes 3, 1 abstention.
11-3, the bill is reported. House Bill 1411, Delegate Leftwich, fiduciaries. More
Okay.
fiduciaries here.
Okay.
Good faith reliance on certificate of qualification.
All right, thank you, Mr. Chairman. So
Bill 1500.
this bill came to me as
1411, I'm sorry.
This bill came to me as an idea of an acquaintance who handles a lot of state work. And essentially what they found is that many times when someone qualifies as an executor, they'll take that qualification to the bank and the bank won't honor it for whatever reason. And so what this bill does, it says, is that a bank may rely on that qualification unless they have good reason not to. And then if there's a necessity, if they haven't relied on the qualification in good faith, then there are some remedies for the executor to follow with the court.
All right.
The bank won't accept a certificate of qualification of a...
They got better things to do.
Well, Mr. Chairman.
Senator
Yes.
Rosenstein.
I've got a real-life example. I want to know how this would impact this. And I start this at risk of sounding like Senator Servell or Senator Peterson, but I had a case. in which just, I guess, last, August, a fiduciary or an executor qualified took the certificate of qualification to the investment bank and asked for them to transfer $300,000. The investment banker who was managing this account actually had reason to believe that there had been financial exploitation that resulted in this will and the qualification of this executor and refused to honor it. Would he have been allowed to do that? And ultimately, the will was overturned, and it was found that it was fraudulently obtained and obtained through undue influence, fraud and undue influence by a lawyer writing a will, leaving everything to himself. Bad situation. Would this allow that bank to disregard that?
Yes, this bill would still allow the bank to disregard it if they had. So,
Line 28 and 29, right? The person in good faith believes the certificate of qualification is not valid.
Yes,
Or the
okay.
personal representative does not have authority to perform. That's, they wouldn't have to accept it.
No.
Is that right?
Would that actually operate that way? Having the certificate of qualification gives that person the authority to perform the act, right?
well, so it says the person shall either accept or reject the certificate. So first of all, it says you have to accept or reject it within 7 days. So you can't just make them wait for like 30 days, 40 days, 60 days, a year, or whatever.
But, so, I mean, here, number 3 on lines 28 and 29, person in good faith believes the certificate of qualification is not valid. In that case, it was valid. It was issued by the clerk of the court. So couldn't reject it under that line, or that the personal representative does not have the authority to perform the act requested, has the certificate of qualification. Why wouldn't he have authority under the law to do that? I mean, they refused to honor it, filed a declaratory or a interpleader action. I mean, I'm concerned that this would send conflicting signals to that bank and say, you know, we've given you, last year we gave banks authority to hold transactions that they think are essentially transactions that arise from financial exploitation. This, I understand what you're trying to do, but I think maybe one of the unintended consequences is that it removes some of that good faith discretion. And I wonder whether we could maybe add a clause that would address those situations in which the authority was, they have reason to believe that the authority was fraudulently or invalidly obtained.
I would certainly be open to that,
Obtained
although
through financial exploitation.
paragraph 1 says they're not required to rely on it if the transaction with a personal representative would be inconsistent with state or federal laws. And obviously, in your example, they're stealing. That's a violation of state and federal law. But I'm happy to entertain. I think I understand where you're going, Senator
Why do you
Shane.
really need
Certainly.
this? Except in an unusual situation, I can't imagine a bank not accepting a certificate of qualification. Have they refused to accept it arbitrarily in some ways?
Yes, the person who brought this bill to me has said they've actually sued a bank on 3 separate occasions and was awarded attorney's fees because they reasonably
Chair.
refused to accept it.
Senator Peterson.
I'm going to move to report and speak to the motion. And I understand Senator Obenshain's concern, and I know he won a significant case in my county, by the way, on that issue. But I think at some point when you get a certificate of qualification from the clerk, it's got to mean something. And I think that's just all this bill says.
All right,
So I move to report.
Anybody supporting the bill? Anybody opposing the bill?
I don't
Would like to
believe so.
stand up and speak? Nobody? Do the banks have a position?
And I'm
Here's a
if
banker coming up.
If I may, I'm happy to work with Senator Obenshain before it hits the floor if you want.
What's the
Very
banker's
simple.
position?
Mr. Chairman, members of the committee, Matt Britting with Virginia Bankers Association. As introduced, we had some concerns about, just instituting the punishments, the penalties for not accepting it. We worked with Delegate Leftwich to at least put in some things, patterns, somewhat after our ability to refuse a power of attorney. So we were comfortable with at least the pieces that we were able to add, again, for the good faith. And, if we understand that there's conflict, or if we don't believe that the certificate of qualification is in effect, if we get two different ones that are conflict, we can pause and say, hey, no. But with those additions, we're fine with the bill.
I'm advised the Virginia Code contains similar provisions for agents under the Power of Attorney Act. Is that right, Christian? Okay. All right,
Mr.
yes,
Chairman,
Senator Ovington.
I'll vote for the bill as long as we can work on some language to make sure that we are not declaring open season on our most vulnerable. And so I'll bring a floor amendment to that effect.
Okay.
Mr. Chairman, I
Yeah.
have a question.
Senator Boyce, go ahead.
I have a question. So I've heard, I'm not an attorney, and this is not my realm of expertise at all, but I've heard discussions of people who have brought lawsuits and had them successfully remedied. How is it that we need, if we've already got a way of dealing with this, that we need?
So I think what it does is it clearly tells the bank what their responsibility is. You have 7 days to accept it or reject it. And if you reject it, you have to have a darn good reason for doing so. And if you have not followed those rules, then there are consequences. So I think, again, it adds clarity in a process that disadvantages the personal representative. They're charged with marshaling the assets, administering those assets in accordance with a will and or a trust. And so you're, by not being able to qualify and grasp those assets and manage them, you're putting the heirs at a disadvantage.
Maybe, probably. Okay, is there a motion? Motion is made to, and seconded to report the bill. All in favor of the motion, say aye. Vote aye. All opposed, no.
Mr. Chairman, 3 out of 4 ain't bad.
Not bad. Good batting average. Let's see. Okay, so
Ayes 14, no, 0, 1 abstention.
14, 0, and 1. Okay. Thank you, Delegate Leftwich. I guess we won't see you again. Okay. Let's see, we have, at this point, get down in the list, I guess, Delegate Simon.
Thank you, Mr. Chairman, members of the committee. I have for you today House Bill 1522, which requires a criminal conviction before you can seize someone's assets civilly. I think it's a fairly simple, straightforward bill. Currently, under current law, you can seize someone's assets even if they're not convicted of the crime, if you can demonstrate by clear and convincing evidence that there was a crime that may have occurred. This says actually you have to be found guilty beyond a reasonable doubt before the police can keep your stuff.
Does it mean, delegates, that the prosecutor cannot file the suit for forfeiture until you're guilty?
Any action for forfeiture commenced under this section shall be stayed until they're found guilty. So they can go ahead and file it, but the decision will be stayed until there's a conviction.
Any questions of the patron?
Yes.
Yes, Senator.
First of all,
Senator Peterson.
I'm kicking myself for not filing this bill myself, because I had this for years. And I guess my question would be, if we're going to have this, are we basically doing away with the whole civil action for forfeiture? Because it would almost be, it would be superfluous to have a civil action for forfeiture if you already get a conviction. I mean, that could theoretically be part of the sentencing phase.
Well, I think counsel seems anxious to answer that question, so I'll let her know. I don't know. Somebody wants to do it.
Is there anybody here to speak for the bill? Is anybody to speak against the bill? Okay, here we go. Prosecutors don't like it.
We have some fours too.
Everybody for the bill first. Okay, for the bill.
Mr. Chairman, members of the
I'll take it. So.
odd couple here. Steve Rossi with the Family Foundation, and we have traditionally supported this bill and appreciate Delegate Simon bringing it forward. Thank you.
Okay. All right,
Good morning, Mr. Chairman. Nathan Green, Commonwealth Attorney for the City of Williamsburg and James City County, speaking on behalf of Virginia Association of Commonwealth Attorneys. We are opposed to the bill. We are very appreciative of the work that Delegate Simons has put into it. It does appear that it would not affect the majority of offices in how they handle asset forfeiture. Majority of offices, as a rule, only seek asset forfeiture when we have a conviction in cases. This rule, though, or this bill, however, would bind things that we make a large effort to keep separate. We don't like the appearance of how much money is going to be forfeited to the Commonwealth to be part of the decision as to what charge to seek or whether or not to do a plea agreement or agree on a specific sentence. In my office, and I think this is routine in all offices that have more than one prosecutor, the person who handles the criminal case does not look at the civil case, and vice versa. What is going to happen with the civil asset forfeiture should in no way be a factor in what type of plea agreement you're going to have or what your charges are going to be. They should be kept separate. This bill ties them in a way that even though it would not have a large effect on what offices do, it would have the appearance that if you are willing to give up this money, you will get a sentence below the guidelines, or you'll get an amendment from a distribution to a possession. It invites that appearance. I don't believe any prosecutor would actually do that, but when it's written together like that, it invites the public to view it that way.
Mr. Chair.
yeah, Senator Peterson.
I'm sorry, sir, I forget.
Nathan Green.
Mr. Green, I had a situation where I had a client that had $100,000 seized during a search warrant. The police held it for 2 years, never charged him, wouldn't return the money. I sued them to get the money back. They then turned around and rather than give the money back, they indicted him on 4 counts. I beat him and he was acquitted. And then they finally gave the money back. But we don't think for a moment that that wasn't what that indictment was about. So these things are always intertwined.
There is,
always.
Mr. Chairman, I can't say that there, again, I cannot say that there aren't going to be circumstances where the oddity does take place, but as a general rule, as I've talked with prosecutors, as a general rule, the offices are not going after assets in which they are not also taking out a criminal charge and pursuing the criminal charge. And the language as it is today allows for the stay, allows for the criminal process to finish before the civil process continues. Again, this is, the way it is drafted, the fact that Delegate Simons included that plea agreements could be a way of doing the asset forfeiture, it again doesn't change what we will do in 98% of the cases. Obviously, there will be oddities out there, but what it also does is it invites the perception that what you did civilly affects what we did criminally.
Which one's that? Discovery? Oh, wait a minute. Torian.
Because that's what's kind of hanging around.
Yeah, okay. I'm sorry, go ahead. Let me ask you another question.
Sure.
The standard is very different in civil forfeiture than in criminal. Criminal is beyond reasonable doubt. Civil forfeiture, the standard is what?
Clear and convincing. Clear and convincing. And there are, I think there are reasons, Mr. Chairman, that we can't use the criminal beyond a reasonable doubt in anything other than criminal. So to use that standard in the civil would not be appropriate or permissible. We felt that clear and convincing was the highest civil standard that we could put into the asset forfeiture. So we were inviting this type of judicial scrutiny of the asset forfeiture cases without using beyond a reasonable doubt. And again, that's only because we can't.
And you say you can get a stay if the criminal case is pending.
Yes. Under current, apologize for interrupting, Mr. Chairman. Under current law, there is provisions that the criminal case will be, the civil case will be stayed while a criminal case is pending.
Maybe my federal background takes over here because the federal system is different, but there are federal forfeitures without criminal cases at all.
Mr. Chairman, I believe that is accurate, and I believe that the reason why we have had a large number of bills that address asset forfeiture is because the federal government does it in a horrible way, and we are perceived to be doing it the way that they do. We do not. In order for the government to seize assets in a criminal case and through a civil process, we have to have shown by clear and convincing evidence that this is either the proceeds of or substantially connected to criminal acts of distribution. We don't do the administrative seizures that the federal government does. All of our asset forfeitures have to go through a judicial process. The individual is given due process and is allowed. We have to prove it in front of a judge, not just claim it administratively.
Is in the state system, can you forfeit the property because it was used in connection with the crime?
Substantial connection with the crime.
Substantial, okay.
Mr. Chair.
Senator Peterson.
This is a question for the delegate. There's two, so basically the money has to be returned, or the funds, the property has to be returned, or it may be forfeited if there's a guilty plea, except, and there's two exceptions, such forfeiture, in no finding of guilt, if such forfeiture is ordered pursuant to a lawful plea agreement, so in other words, you make a plea deal and say, okay, you can have the property, or two, the owner of the property, the person in custody, has not submitted a written demand for return of the property with the law enforcement agency that seized the property within 21 days from the date the stay terminates. So if you know, you're just some poor sap and they seize my car, they seize my funds, and I get acquitted, but then I don't make a request within 21 days, they get to keep the car?
So it does put a burden, the way the bill's drafted, it puts a burden on them to ask for it back within 3 weeks.
Why?
I think that's the way that the bill's been introduced in the past, I'll be honest with you. I don't
Okay,
know.
well, I may have
I'm not
introduced
married
it.
to that clause.
Well, unless someone can give me a good reason, I'd like to strike it, because I don't see that, if it's my property, I don't need to make a written demand to get it back, I gotta
Mr.
give it
Chairman,
back.
here's why.
Okay.
In many cases in which the person who was the owner of the property has absconded, has never been captured. You have a suitcase full of cash.
Okay.
And they're gone, vamoosed.
Okay, can I just simply add a clause, and maybe we could do this with a floor amendment, just saying that the court shall give notice to that person so they don't lose that right?
But
Senator O'Shane.
They may not even know who they are.
All right. Okay, Senator Stewart.
I mean, it could be a part of a drug deal.
Mr. Chairman.
Or drug transaction.
Senator Stewart.
The fact of the matter is sometimes people don't want the court or the law enforcement to know that this is their property.
That's exactly right. Okay, just that. Let me ask you this question, because this happened in a situation I had one time. The property was forfeited, or was seized, and they sat on it and sat on it. No charges were ever brought. They sat on it and they sat on it. I had to go to court, get a judge to give them set a time. Either you prosecute or you turn the thing back over. And they eventually turned it back over. But what is the remedy? They seize it and they don't do anything. And there's no charges ever brought.
Yeah, so,
Is there in a current law?
Mr. Chairman, I was going to say, this bill doesn't really address that issue.
Okay, well, let me ask the prosecutor. In current law, what is it? Because I don't think there is any.
There is a time frame in the code that dictates once the items are seized, a notice has to be provided to the property owner and has to be docketed in circuit court. I don't know why it wasn't done in your situation. The case can be continued. You could ask for continuance after continuance, but again, it is at least it's not being held by the executive. It is at least being reviewed by the judicial.
Well, it was held because the prosecutor says I'm still deciding whether to prosecute or not.
And if the judge agrees to continue to continue those cases out, at least the judge is looking at it.
They ordered him to give him 6 months or whatever, and there was no law on the subject at all. Okay, is there any further discussion?
I'm gonna move to report.
Goes to finance. I'm not in favor of the bill. I think prosecutor's right. I don't think you need it, but that's my vote. All right, all in favor of the motion to report, vote aye, and refer to finance.
Ayes 14, noes 1.
Okay, 14-1.
Thank you, members of the committee, Mr. Chairman.
Okay, thank you. All right, now the next one, let's see, just going down a list here. Bourne, Delegate Bourne, okay.
Good morning, Mr. Chairman, members of the committee.
You
I
just
believe we
got
have
the
House Bill 873.
Discovery.
Yes,
This
sir.
is identical to mine, which we carried over for the year, I believe.
I'm not sure whether your original version was exactly like what passed out of the House, because we've had a substitute that we worked on, which builds upon the Supreme Court rule that is, I guess, arguably ready to be implemented. As many know, they've developed these rules and punted for a couple times. But basically what this does is it puts in place some discovery rules, much like we have in a civil context. There's a lot of similarities between the Supreme Court rule, but there are some differences. Discovery can be initiated by voluntary request and agreement. Discoveries provided in a reasonable time to use material. It must be responded to 14 days before, prior to trial of misdemeanor, 30 days for a felony, 90 days for those more serious felonies. Discovery has to be provided prior to a plea offer expiration. Both sides must provide the witnesses' names and designations, exceptions to protect confidential informants unless ordered by the court. So yeah, I mean, it really just builds upon that, puts a little bit more accountability measures and some timeframes with which to respond. I'd be happy to try and answer any questions that the committee might have.
It's a pretty big, confusing bill. Who's in favor of the bill? Anybody here speak in favor of the bill?
Ms. Taylor is.
Okay. And then we'll have the people speak against the bill.
Good morning, Maria Jankowski, Virginia Indigent Defense Commission. We appreciate Delegate Bourne's hard work on this issue. We need discovery. We really need discovery, and we're not getting it.
Kenny, okay, next.
Good morning, Dominique Martin, New Virginia Majority Policy Analyst, and we support the bill.
And you're with who? Who are you with?
New Virginia Majority.
Okay, all right. All right, who else in favor of the bill?
Mr. Chairman, I failed to say one thing about this bill. In working to kind of get it to this point, one of the significant changes we made was to put an enactment clause on there that says this will only go into effect should the Supreme Court fail to adopt their rule. We're sort of stepping out on faith a little bit, but also having a backstop that if they fail to put in the discovery rule, we'll codify it.
Okay, against the bill?
Good morning, Mr. Chairman. Shannon Taylor. I'm the Commonwealth Attorney for Henrico County. I do want this committee to know that I was part of the committee that came up with this rule. That was comprised of Court Appeals, Judge Humphreys, Judge Bellows, Circuit Court Fairfax, two public defenders, including the Executive Director, Mr. Dave Johnson, as well as Doug Ramser from the Capitol, three private attorneys, five of the prosecutors in the area, looking at different areas in the Commonwealth. As I have been saying to those who have had an opportunity to speak to, this rule was really vetted in terms of what is going to come into effect July 1st. And as I say, it's the true definition of negotiation. Both sides walked away. When I say both sides, meaning prosecutors and defense attorneys, not happy because of the negotiations that did take place. I will tell this body that to date, Henrico County has actually drafted an order that mirrors this rule that we have shared with our colleagues across the Commonwealth, and we are implementing it. As I can tell from about from a third of the colleagues who have responded, it's about 99% compliant. The matter that has not been addressed by my colleagues that is in this rule is this exchange of witness lists, and that's because no one's compelled to follow it right now. So some of our defense bar is not necessarily comfortable with doing that.
Let me say, that is the problem. I mean.
Yes, sir. I mean, I think that we looked at that, the exchange of witness information, also the expert information that's being exchanged. I do want to say I do appreciate Delegate Bourne letting us sit down and talk with him. We do appreciate his concerns regarding the copies provided, the reciprocity that's being reflected, and the timeliness and deadlines. However, there was some concern about some of the deadlines that were reflected in the discovery rule that's being proposed. The bill that's being proposed. I would also mention that there are 3 points that are different in the bill that are different from the rule, and that being in lines 21 through 23, talking about following the rule. If there are matters inside the bill that conflict with the rule, how do we negotiate, or how do we interpret the inconsistencies? When we're talking about lines 67 through 87, this idea of providing the evidence before the plea, we like to hope that everyone is playing on the level playing field when we're trying to negotiate. That's not something that has been codified before. Lastly, with lines 139 through 141, I would reflect that we talk about the Brady rules with 3.8 subsection D in our rules of professional responsibility. I also sit on the State Bar Ethics Committee, and the language that is the expeditiously may not be interpreted as the same as the timely disclosure. There's been a lot of talk about what these words mean, and for those reasons, we would just simply think that the rule should have the ability to go into effect. We would respectfully disagree with the enactment clause at the end, that this be kind of a catch-all phrase, because what we have vetted in that rule is something that has been seen from all sides, from our judges, from our prosecutors, from our defense attorneys, and we have not had the ability to have the same vetting process with Delegate Bourne's bill, which again, we certainly do appreciate. I certainly appreciate what he's trying to get to, but we really think that this rule that will be going into effect July 1st can still accomplish those same goals. We just simply request that we send this matter over to do that.
Mr. Chair.
Okay.
If I can ask, if you're confident that the rules can go into effect July 1st, what's the harm of passing this bill?
Mr. Chair, Senator Deeds, who knows what could happen when it comes off the floor? That's the only thing that could happen. And none of us have a crystal ball to ensure that everything is going to be done the right way. I don't know. But it would certainly, I think it's an appreciation for the hard work that everyone put into the rule to let the rule go into effect.
Mr. Peterson. I would simply ask Delegate Bourne, as I understand, he's not standing in the way of the Supreme Court. This only takes effect if their rules don't take effect July 1st, 2020.
Mr. Chairman, I would say to Senator Peterson, that's absolutely right, because I think the rule that is being contemplated by the Supreme Court now is this, at least the second time where they've developed some rules but yet failed to implement them. And so what I would want to do is just make sure that if they're not going to adopt the rule,
right,
that because to me, the point is in civil matters, as you know, we have a very stringent discovery process, and we're only talking about some sort of injunctive relief or some sort of monetary damages.
Right.
And we don't have these same types of rules.
Right. Let me ask a follow-up. These
Yes,
are
sir.
friendly questions, by the way.
Senator Peterson.
So the bottom line is, since I've been in the Senate, which is now 13 years, we've been trying to get criminal discovery rules. And every single year, the Supreme Court says, don't do it. We're about to enact our own rules. And so this is basically saying, hey, your feet are to the fire now. Y'all don't enact them. This is what's going to go on the books. Correct?
Mr. Chairman, I would say to Senator Peterson, he's absolutely right.
All right, thanks.
Mr. Chairman.
Yeah, Senator Overton.
Abstain.
Thank you. I would say that the part of the reason that the Supreme Court and this committee, I think, has been reluctant to do this in the past is judicial manpower. This is going to take considerable judicial manpower, or has the potential to, and fortunately last year we did fill a good number of the recommended judicial slots, but I am just concerned, especially given some of the other measures that are working their way through the General Assembly, that we're going to be putting an awful lot on the plates of our circuit court judges around the Commonwealth of Virginia, and it may have a significant impact upon court dockets and ability, particularly civil litigants, to get trial dates.
Mr. Chairman.
Yeah, Senator Stanley.
Mr. Chairman, as you know, and probably everybody on this committee knows, I have filed discovery reform bills for a number of years, getting so far as to the courts of justice in the House, when I was told if it wasn't done, then we could bring it back the next year. I then had the bill the next year. The second commission came together. They passed what would be, to the liking of the Supreme Court, what would be significant reform. I then held my bill for a year because that was supposed to go in last year, and it did not. And the reason why, Mr. Chairman, members of this committee, was because they said they didn't have money. And that they needed money, and that there might be extra manpower needs in some of the larger Commonwealth's attorney's office that would need
that manpower in order to handle what would be required in the disclosure. The question then I ask either the patron or anyone who sits on finance, do we have that money that was needed to implement this in this budget?
No more
or
sidebars, please.
Mr. Chair, the
Or the
bill
House
has to
budget.
go to finance if it leaves here. They've requested it.
Okay, but I guess what I'm saying is we've passed a budget, and I apologize for not being more meticulous because I held up filing this bill because of, no, we're gonna do it, no, we're gonna do it next year, we'll have the money in the budget, we'll have the money in the budget. Do we have, who on finance here can tell me that we have put money in the budget to implement the discovery rules? And
Mr. Chairman,
Born, you may know.
Mr. Chairman, I would say to Senator Stanley that at no point has anyone raised a fiscal impact. The fiscal impact statement that I have says it's indeterminate, did not require a budget amendment. And so while I certainly think that everyone involved in a criminal proceeding might have to work a little bit harder, I'm not sure that it would cause a significant or any fiscal strain on the judiciary.
And Mr. Chairman.
Senator Stanley.
And so then my question was, because they said it did have a financial need to help out some of our Commonwealth's Attorney's Office, are we satisfied that that requirement that held it up last year has been satisfied by this biennium budget? Jen?
Mr. Chair, I would respond by saying that it's usually the Finance Committee that answers that. I don't remember off the top of my head. The budget is pretty big, but we have really good Finance Committee staff who in that committee will tell us whether we have it in the budget or not. This committee usually makes the policy determination. If we think this is a good policy, we should say so and send it up to the Finance Committee to determine if we have the money needed to carry it out.
And so, Mr. Chair, finally.
Senator Stanley.
Thank you, sir. Again, this came out of this committee, when I was carrying it, came out of the Senate, passed, and then was held up in the House courts. And that's when the commission was started. And then when the commission had done its work, then we said, let's put it in the budget. And they said, no, it needs money. We're going to hold off a year. I'm just making sure, because otherwise, I see no harm in passing Delegate Bourne's bill to the Finance Committee. Maybe it becomes redundant. As long as I'm assured that either version is going in July 1, then I'm going to be happy. But
And Mr. Chairman, I would say that while there was or could have been some financial impact or fiscal impact to the budget with the original version, I think we've done a lot of work to reduce that or eliminate any sort of fiscal impact that may be there. So.
Okay, Delegate Bourne.
Thank you, Mr. Chairman.
I've always supported expanding discovery and especially the statements. This bill, though, is so detailed. There's some things in it that kind of scare me a little bit. For example, a party requesting discovery shall, before filing a motion for discovery, request in writing voluntary compliance. You got to wait so many days, and then you need to file, after that, if they don't comply, you got to file a motion. It's all these detailed things. I mean, I guess in a complicated, big case, you could do it. But in an average, routine kind of case, you're going to be the lawyer's going to be jumping through a lot of hoops, and it's going to be, it's much too detailed and specific as far as I'm concerned.
Mr. Chairman, I would simply respond that the bill actually seeks, with that part of the discovery, to make it less about a motions practice and more request by and between the attorneys, much like we have in the civil process where you would serve interrogatories or request for admission and only at that point where the other party didn't respond and you had gone through the good faith efforts to get the information, would you then file a motion to compel that?
I'm sure most prosecutors are that way, but sometimes maybe they're not.
Mr. Chairman,
yeah.
I have a question. It may be a question for Ms. Taylor. What I've seen in recent years and currently is that search warrants and the underlying affidavits are almost always sealed, especially in narcotics cases. And in at least one jurisdiction, and not Henrico, the chief drug prosecutor has told me that if I succeed in getting an affidavit unsealed in the circuit court, then there'll be no offers, no negotiation for a guilty plea, which of course hinders us in our ability to defend. One of the things that I like about this bill is on line, beginning at line, you don't need to refer to it, it's just line 155, it says that, 155, that whenever there's been a search warrant,
then the search warrant and any accompanying exhibits must be unsealed or provided to the defense. And in another part of the bill, it would provide that that must be done before a guilty plea. Is that provision that extends to the unsealing of search warrants and affidavits, is that in the proposed rule?
Off the top of my head, I've got it right here.
Sorry, I didn't mean to
What I can tell you is there should be no excuse anymore about not providing that information because we do have the provisions of the restricted dissemination material. Therefore, there's nothing that should not be able to be provided to defense counsel. But if we're concerned about the defendant having access to that information, then there is a provision that allows for that. So there should be no reason why defense counsel is not getting everything that they're entitled to because we provided for two protections, the restricted dissemination material as well as a protective order.
Thank you.
Yes, sir.
Okay, all right. Any further discussion on the bill? It's got to go to finance. Is there any kind of motion? Is there a second? Motion to report and re-refer to finance. All right, all in favor of the motion, vote aye. All opposed, no. Okay.
Ayes 12, noes 3.
As 12, noes 3.
I thank the committee for their
motion
time.
carries. Yeah, thank you. The bill is reported. We have House Bill, Delegate Mullen has a bill, House Bill 673, and Delegate Torian 1250 need to be dealt with today because of the fiscal impacts and because of the time constraints. We're going to have to come back Wednesday, I suspect. So, all right. I think that's going to be the case because we still have a few more bills. All right, Delegate Mullen, what's your bill? It's
673.
670, cruelty to
Mr.
children.
Chair. That's correct.
Okay.
I believe there's a substitute that was approved by the House.
We haven't looked at this before. This is new.
This is the one that you analyzed. You put a substitute on while I was standing here.
That's right.
And
You don't
then
like
said that I should wait,
Okay. Okay.
even though I accepted your substitute.
Okay. So explain it again. What's the substitute do?
It's your substitute, sir. It's not mine.
Yeah, staff substitute. Yeah. Cruelty to children. Staff explained, yeah, it's has to do with torturing children and it's classified for felony.
So, Mr. Chairman,
I think we've already adopted the substitute, I believe.
yes, the substitute was adopted on Wednesday. The substitute relocates the child labor provisions to 18.2. In the bill that came over from the House, there were essentially two provisions, one dealing with negligence and one dealing with the willful actions. This bill has deleted the negligence provisions as the committee has been reluctant to criminalize negligent actions and just provides the willful provisions in the 18.2 section and treats the, and I'll read it, it's on lines 97 to 99. It shall be unlawful for any person employing or having the custody of any child to willfully cause or permit such child to be tortured physically or psychologically, tormented, mutilated, beaten, or cruelly treated, and any person violating this subsection is guilty of a Class 4 felony. And that's essentially what the substitute does.
Okay. All right, I think we adopted the substitute last time, didn't we?
And I just asked, Mr. Chair,
Oh, wait, did we adopt the substitute? Yeah, okay.
I'd ask staff about this the psychologically tormented, mutilated, beaten, or cruelly treated. Do we have definitions anywhere in the law for psychologically?
Mr. Chair, I would answer Senator Deeds' question. There is no definition for psychologically. This language was in the bill from the House as it came over. I would defer to the patron, but I believe he said that, one of the rules of statutory construction is the plain meaning of words would apply, and I believe that's what was offered last time.
And,
Okay.
Mr. Chair, may
Yeah,
I answer the senator's question?
Delegate Mullen?
That's right. This bill does two primary things. First is it adds psychological torture into the code. So that is a new idea.
Well, Mr. Chair, I'd wonder if you're, I guess understand what you're getting at, but would you be better to use the word emotionally? Would that be closer to what you're seeking, or?
So the case that was the impetus of this was a mother down in Suffolk who was with her, I believe, 7-year-old girl, keeping her in a dog cage and shaving her head so as to embarrass her in front of her students or friends and family. And that was considered not physical torture, not physical abuse. And so this is to include psychological. If it is the will of the committee,
How
I think.
about emotional distress? Is that a fair? Yeah.
Sorry.
Yeah, Senator McClellan.
Two quick questions. One, does any other state have a similar sort of psychologically torture or statute that could give us some?
So, Mr. Chair, I would respond to the senator that we are in the minority of states that don't separate out torture from other types of physical abuse. And there are approximately 17 states, I'm going off the top of my head right now though, so Mr. Quagliato, if I'm, that have some form of psychological torture. We use the same sort of language as we did there, but council is now giving me a look like, no. So as I was saying to Senator Deeds, this does two things. First, it increases the penalty when it's willfully torturing a child. And then it also creates a Class 6 new structure for psychological torture.
Okay.
And so I think it would.
Mr. Chairman.
No, Class 4 for willful.
I'm not finished. So let me give you an example. We've seen stories where if a parent may, as punishment, have a child stand outside with a sign saying what they did wrong in an effort to embarrass the child, would that be prosecutable under this?
I think it would be something where there would be a large discussion on whether or not they should be charged, and that would be reflective of the community in which the charge was brought. But I don't know. I think when you get to willful psychological torture, that is such a higher standard than what you would have that would not constitute just normal abuse and neglect. And so I can't imagine that those cases would be.
Final question.
Yeah, Senator
McClellan. And again, I don't practice in this area, so why wouldn't the infliction of emotional distress statute cover? What does this provide that you don't get under infliction of emotional distress?
Well, I think that there's a large category of law that talks about intentional infliction of emotional distress that we've already had, that adding psychological to it would be a separate definition. And so that, intentional infliction of emotional distress is usually those cases in which there has been a willful action, in which case you would probably have this as the Class 4 anyway. So that would increase the penalties in those circumstances because intentional infliction of emotional distress is by its very nature intentional. You can't accidentally do it. But there are other provisions in here in which you can negligently, for example, torture a child. And so I think this would include negligent torture of a child.
Mr. Chairman.
Senator Zerbel.
Thank you. I have a question for the patron, maybe council. I'm trying to understand how to read this. And the way I think I construct this, it says it's unlawful to willfully cause permit a child to be tortured. Okay. Then it says physically or psychologically. And I assume physically or psychologically is intended to modify the next few words. So then it says, okay, well, right now this bill says that it's a Class 4 felony for a child to be tortured, beaten? I mean, or tortured, physically beaten? I mean, I'm trying to understand how to work all these words together. And, you know, child neglect is already a felony. Domestic assault is already a felony. I mean, a misdemeanor, unless it's a third, then it's a felony. I'm just trying to understand how to work all these words together, because there's a lot of words in here, and you have to read them together, and I'm not getting it.
Yes.
I would defer to counsel who has been
Senator
making
Overchain.
some.
Senator Overchain. Okay.
I would defer to counsel at this
Mr.
point.
Chair, the words would read that the action or the crime would be any child who was willfully caused or permitted such child to be tortured physically or psychologically, or tormented, or mutilated, or beaten, or cruelly treated. So if you are employing a child and you willfully cause such child to be mutilated, it doesn't matter if it is physically or psychologically.
Got it. Mr. Chairman, further question for counsel.
Yes, Senator Sherrill.
So for counsel, how do you differentiate somebody who maliciously wounds a child from somebody who physically mutilates a child? Or how do you differentiate child neglect or domestic assault for somebody who physically beatens a child as opposed to existing code?
I would say that's current code. I'm not changing anything.
Well, you're making a
involving
class
that
1 felony.
It is already a class 6 felony. Plus, you would also be malicious wounding, plus you would do cruelty to children, plus you would probably do some other form of that. Cruelty to children and child abuse and neglect are routinely tried together and have been found to have passed the Blockberger test.
Mr. Chairman, I have a question for counsel.
Yeah, Senator Sherrill.
Am I not mistaken that domestic assault is a class 1 misdemeanor?
Yes. That's correct, Mr. Chair.
Okay, then how is that different from somebody who physically beats a child? Wait, I'm just trying to understand.
They have different elements. And so you can charge them both because they have different elements. Right now, any unlawful touching of a family member can constitute assault and battery of a family member. There is also a separate statute that says that under 40.1-103 that you cannot cruelly treat a child. And then you also have the child abuse and neglect statute. Cruelty to children and child abuse and neglect are 2 class 6 felonies. This raises it in the case of it being intentional torture to a class 4.
Mr. Chairman.
Senator Sherrill.
I guess question for the page. Again, this sentence to me is word salad. And I'm trying to read it all together in a way that I think it has to be constructed, so that every child abuse case doesn't turn into a class 4 torture case. Or every child, let me ask my question,
Yes,
or
sir.
every domestic assault turns into a class 4 torture. So this says, the way I think I have to read it is, shall be unlawful for any person having custody of a child to willfully cause or permit such a child to be tortured physically, okay, tortured, beaten. I mean, how do I work these words together with this list that you have afterwards? That's what I don't understand, how to construct it as a sentence.
So I guess, Mr. Chair, I would respond that first, that is reflecting current law, and also there was a substitute laid on here by this committee that is substantively different from my original language.
Okay. Maybe counsel can answer my question then, because I don't understand how to read this.
Mr. Chair, I think I can help if I can make a suggestion.
Senator Morrissey.
You all are talking over each other. The words to be tortured physically or psychologically, the words physically or psychologically apply to tortured. The word should be changed, or the phrase should be changed, or permit such child to be physically or psychologically tortured, comma. Let's just do that first. That will assuage Senator Servo, and then we'll move on to my next point. So I'm going to make that as a motion. We're going to move the word tortured to after the word psychologically, so that it will now read to be physically or psychologically tortured.
And that's the end of the sentence, is that right?
Now, then comma, then we'll get on to the other word.
Mr. Chairman.
That's the first thing.
Mr. Chairman.
Go ahead, Senator Sherrill.
Well, okay, then.
Is that a motion?
Okay.
Is there a second?
Okay, well, speaking to the
Go ahead,
motion.
Speaking to the motion.
Thank you. Then it would seem to me the bill needs a comma after physically, and we need to strike the word or. And again, I'm still not clear how this is different from domestic assault. I mean, if you willfully beat a child, that's domestic assault. Now, if you beat him really bad, maybe it gets to neglect. If you beat him really bad, it gets to malicious wounding. I'm just not clear what this bill adds.
That's the next point that I want to get to, Mr. Chairman, but first, if we can just get the wording organized. It's
Mr. Chairman,
Steve.
let me caution against making that change. If you moved tortured to after physically or psychologically, then the physically and psychologically would also extend to tormented, mutilated, beaten, and the following. So I think it's fine right where it is, although there is one other concern. Senator McClellan's example and the patron's response flesh out one of the problems here, and that is vagueness with the word psychologically. A principle with criminal legislation is that when you criminalize something, it must be sufficiently clear that it can give the public notice of conduct that is prohibited by the criminal statute. And the example is an excellent one because it would not be clear to parents that whether putting a child outside with a sign is psychological torture or not. And so the vagueness that adheres to the word psychologically, that would be a constitutional concern.
All right, let me point out to the committee, we have another bill that needs to go to finance and it needs to be dealt with today. And I understand Delegate Hope and Delegate Bell have some witnesses here.
I definitely don't.
Is that correct? Okay. All right, so we need to move along one way or the other. Yeah, Senator Morsi.
Senator Serville had a point when he said that the words in there cover a wide breadth. For example, tormented. That covers a lot of territory, as does cruelly treated, as does the word psychologically. Additionally, mutilated would be covered under aggravated malicious wounding. I think we could come to a meeting of the minds on this language, but I don't think we can do it right now with all the concerns. And I'm certainly willing to get together with the patron, either later today or another day to wordsmith this a little clearer.
Mr. Chair, the problem is this bill has to go to finance. Now, it's my understanding today's our last day to act on bills that have to go to finance. And we have to decide whether having a bad decision from a bad judge, apparently, is worth amending the code for.
Is there a motion of any sort?
I move that we write a letter to the judge in Suffolk and tell him to figure things out.
I'm sure they'll be very receptive of that.
Well, is there a motion we refer it to the Crime Commission or pass it by for the year or what? Anything? Any kind of motion? Pass it by temporarily so we can take care of these other bills and come back? Yes, Senator Serville. We got another bill to deal with to get in finance, and we got two people who want to be.
Can we just go by temporarily so I can talk to the patron really quick?
All right, pass it by temporarily. All right, without objection. Senator Torian, Delegate Torian, do you have a community policing data collection?
I do.
Okay.
Mr. Chairman and committee, House Bill 1250 is my Community Policing Act. In the practice of policing, bias-based profiling, unwarranted property searches, and the use of excessive forces are serious concerns. And I have a substitute.
Okay, is a motion to adopt the substitute? Is a motion made and seconded to adopt the substitute? All in favor of this motion, say aye. Aye, all opposed, no. Okay, 1250.
Thank you, Mr. Chairman. The Community Policing Act will deter and increase accountability for this misuse of power by directing the Department of State Police to create and maintain a comprehensive database of the basis and outcome of every state and local office traffic stop. What the bill does, the bill directs the Department of State Police to create the Community Policing Report Database, to which sheriffs, local police forces, and state police officers report certain data pertaining to motor vehicle or investigatory stops. Specifically, what the bill does is requires that each time a local law enforcement officer or state police officer stops a driver of a motor vehicle, that the officer collects the following data: the race, ethnicity, age, and gender of the person stopped, the reason for the stop, the location of the stop, whether a warning, written citation, or summons was issued, or whether any person were arrested. If any other form occurred, the warning provided a crime or violation charge, and whether the vehicle or any person was searched. This information will be collected and gathered, and it will be analyzed by the Department of Criminal Justice Services. And that's what the bill does.
Okay. Anybody in favor of the bill? Anybody against the bill? Yeah, who's in favor of the bill? Go quickly.
Hello, again, committee, Dominic Martin, Policy Analyst, New Virginia Majority. For the reasons stated, we do support the bill.
Okay. All right, is there
Mr.
any?
Chair?
Yeah, Senator Morrissey.
Let me tell you why this bill is good. When an individual is stopped, irrespective of their race, and that car is searched, irrespective of the offense, and then is proceeded to go on down the road, we now have a database to determine whether there is wanton stopping of vehicles and searching it. If for no other reason, that's a reason to support this bill. And
is there a motion to?
Motion to report.
And re-refer.
Mr. Chairman?
Yeah, Senator.
Mr. Chairman.
McDougal.
McDougal. The other M on the other side.
The other
Mr.
M.
Chairman, I want to thank Delegate Torgan. This looks like it's a lot different than the version that was introduced. I had a number of people that contacted me about concern about the wording of the other one. I think this addresses it, but I'm going to just abstain so I can have them look at it. But I want to thank him for taking the effort to hear some of the concerns that were expressed. I think the idea of what he's trying to get to is a laudable idea. I just want to have them look at it, but I wanted to thank him publicly for trying to address some of those concerns.
Okay, the motion's been made and seconded to report the substitute and re-refer to finance. All in favor of the motion, vote aye. All opposed, no. Motion.
Ayes 13, no, 0, 2 abstentions.
13-0, the motion is reported. The substitute has been reported and re-referred to finance.
Thank you, Mr. Chairman.
Okay, thank you. Okay, now how are we doing with this other bill? With Mullins' bill? Yeah, is there anything? Where are we?
Chairman?
Yeah.
On Mullins' bill, I would move to carry over to 2021 with a letter to the Crime Commission.
Okay, is there a second?
Second.
All in favor of the motion, vote aye. Vote aye. Opposed, no. Okay.
Ayes 15, no, 0.
Ayes 15, no, 0. Now, I understand there are two, Delegate Bell and Delegate Collins, is that right? Who have witnesses? Who has witnesses? How many people are, yeah, Delegate Bell, come on
No,
up.
it's just some, we don't have to present the whole bill, but we have out-of-town witnesses who'd like to.
Yeah, please do, okay?
I think that's the three of us. We'd love to have the bills heard, but we understand you've got other concerns. But
Yeah, time constraints. Okay,
Mr. Chair, this is House Bill 1573, rabid animals. Again, this gentleman has come from some distance. We just want to tell you what happened, and we can take the bill up at your convenience.
House Bill 1573 regarding rabid animals, yeah.
Good morning,
Thank
Mr.
you.
Chairman,
Thank you.
members of
Well,
the committee.
Thanks for coming.
Yes, sir. My name is Richard Schmack. I'm a retired fire captain, and I live in Scottsville, Virginia, County of Fluvanna. On December the 19th of last year, my daughter, who was 14, got off her school bus, was walking up our driveway, and was attacked by a pit bull that we found out later to belong to our neighbor, and subsequently tested positive for rabies. That animal was supposed to be under quarantine the day of the attack, and the previous day had attacked a neighbor's dog. The injury sustained by my daughter in the attack was she is right dominant. The animal severed her right index finger off. I found the finger in the yard. She was transported to UVA, where they were unable to successfully reattach that digit and had to have it surgically amputated. Excuse me. In the process, and going through the judicial system, as it were, at this point, we have found that the laws regarding this type of an attack by an animal that is supposed to be in quarantine are less for an individual than they are for animals in the Commonwealth of Virginia. Had this happened to an animal that I own, the significance of it would have been much more than a Class 4 misdemeanor. And on behalf of my daughter and the rest of the citizens of the Commonwealth, we ask that you seriously consider raising this, as Delegate Bell has proposed, to something that is substantially more than a Class 4 misdemeanor for a bodily injury and maiming. My daughter has been maimed for life and will continue to suffer in that traumatic day over and over. Thank you.
Okay, thank you.
Mr. Chair, and at appropriate time, we'll present the bill that we think would fix this. Thank you.
Okay, is there somebody else?
Yeah, just briefly, Mr. Chairman, members of the committee, thank you. I'm Jeff Hayslip, Commonwealth's attorney in Fluvanna. I've been working with this family and delivering them the bad news that there's very little that can be done except for a Class 4 misdemeanor. I think what this will do is when someone takes it upon themselves to quarantine a dog that is suspected to have rabies, the animal control officer or the health department can say, if this dog gets out, this is a Class 1 misdemeanor. Right now, it's a Class 4 misdemeanor. There's really no concern for the animal owner. This will, I think, give great incentive for the person who takes that risk to make sure that animal doesn't get off of his property. Thank you.
Is there, maybe we can deal with it now. I don't know. Is anybody against the bill?
I'm not aware of anyone. Staff has an approach they like better than what we did in the House. I don't object to it.
You don't like the staff? Yeah, staff, go ahead.
Mr. Chairman, our suggestion would be as follows. Delete the language on lines 26 through 29, and in lines 38 through 42, and this would make it a Class 1 misdemeanor, use the following language. So it would be a Class 1 misdemeanor for a person to, here's the new language, permit a dog or cat that he owns or is in his custody to stray from his premises when he knows or has been told by the local health department, law enforcement agency, animal control agency, or any other person who has a duty to control or respond to a risk of rabies exposure that the dog or cat is suspected of having rabies.
You don't object?
I don't. I mean, we've formalized it into a agreement or order. VDH has forms that they use that they serve on you and say, Ms. McClellan, your dog is acting very strangely. We can take it, put it down, or you can quarantine it. And that this is a little more open about just how the process goes. This would be, but it's a formal warning, said you have to keep this dog on your property. We think it has rabies. You're gonna have to make sure it doesn't get off for 14 days or whatever the time is until we can find out.
So you do not like the substitute?
He does.
I'm fine with the substitute, that's what I'm saying.
You
Yeah,
do like it?
I'm fine with it, yeah.
Mr. Chair, I move the amendment.
All right, the amendment has been moved, has been seconded. All in favor of the amendment? Is this an amendment or substitute?
Yes.
Substitute. All in favor of the substitute vote, say aye. Aye. All opposed, no. Okay, it's moved. Is anybody against the bill?
I've never
All right.
heard of anyone.
All in favor of the motion to report the substitute, vote aye. All opposed, vote no. Good. You don't have to come back.
I don't have to, thank you.
Yeah.
Neither does he, thank you.
Thank you very much. Okay, Collins and who else? Hope? Who has a witness? Everybody has a witness? Okay, who's in order? Collins is next in order, if you have a witness.
Thank you, Mr. Chairman. I would ask them come up briefly. Basically, it's the Family Law Coalition speaking on the bill, dealing with spousal support.
Okay.
Mr. Chairman, members of the committee, my name is Dan Gray. I'm the chairman of the Virginia Family Law Coalition. The bill that's being introduced, with our gratitude from Delegate Collins, changes the existing spousal support guideline in Virginia. As most of you know, in 2017, the federal government made spousal support non-deductible and non-taxable to the recipient. And so there was a clamor from Virginia judges and Virginia practitioners to revise the guidelines that control in every juvenile court in Virginia. And so what this bill does is reduces the current percentage of the payor's income from 28% to 26%, and then to 27% where there are children. And so what this does is gives the payor a break. You're not paying as much as you were when spousal support was deductible. But what we tried to do was keep the support recipient in roughly the same position. So from a policy perspective, this does give the support payor a break. and it also preserves the amount of support to the extent we can after taking into account taxes that the support recipient is getting. The other thing the bill does is it gives this guideline to every circuit court in Virginia. And that has been something that the members of our coalition and practitioners throughout the Commonwealth have been looking for
Okay,
some
is
time.
Anybody against the bill? Is there a motion to report? Been moved and seconded.
Mr. Chairman,
Yes,
I realize
Senator.
that this is
Yeah,
a pretty
McDougal.
big change, I think. What is the anticipated tax implication difference between this approach and where it is currently?
Well, it depends on what the payor's income is and what the recipient's income is, but we looked at, this bill only, it confines the application of the guidelines to situations where the combined gross incomes of the parties is $10,000 or less. So in that circumstance, the tax impact is somewhat standardized. Once you get above incomes of $10,000, the guidelines are no longer presumptive because there's so much that can be done with taxes. But the short answer, Mr. Chairman.
Is that $10,000 a month or a year?
$10,000 a month.
Okay.
Correct. The short answer is that it will save the support payor a few thousand a year, and it will have, we tried to have a negligible impact in terms of what the recipient is getting.
Okay, is there anybody against the bill? Is there a motion? Is there a motion? Is there a motion to report? Then a motion to report the bill. All in favor of the motion, vote aye. All opposed, no. Vote no. Okay.
Ayes 15, no zero.
Okay.
And Mr. Chairman, I assume I have 1501, but I assume you want to pass that by until, right? Because I think Senator Surville and I are going to have a conversation.
Okay, all right, yeah, Delegate Hope, and then we'll go from there.
Mr. Chairman,
Yeah,
my witness will come back on Wednesday, so, and it will.
okay, all right, Levine?
Thank you, Mr. Chairman. HB 863.
Yeah, we have you have a witness, okay?
I do.
What's
I do.
the
He
bill?
actually, HB 863 greatly simplifies the process by which wedding officiants are chosen. It allows the parties to choose any wedding officiant they want. Can be Uncle Joe, can be mom or dad, can be their best friend from out of town. Under current law, and I've done this 3 times, you have to go to court 4 times. If you want to be a wedding officiant, you go. Then you file a motion saying how you know the parties. The judge has to take time to review those motions, has to say.
Let's hear your witness.
Sure, let's have the
I don't know
witness.
if you voted
Come on
down
up.
or not, but if you got a witness here, we want to take care of him.
Mr. Chairman, my name is Lewis King. I'm with American Marriage Ministries. We're a national church, and we've ordained almost 10,000 ministers in the Commonwealth of Virginia as wedding officiants, and HB 863 will finally end religious discrimination against wedding officiants. A number of our officiants were here earlier today, and they couldn't make it, and I speak for them as well as dozens of others that reached out for me. And these are friends, grandmothers, other relatives, and they've all been rejected by county clerks, and these rejections really sting, but their stories are just a fraction of the thousands of Virginians who are turned away by county clerks every year because all they want to do is be a part of this incredibly important event.
Why are they turned away?
Well, they're turned away for a number of reasons, but it's primarily because they're discriminating based on different churches. So American Marriage Ministries, they don't respect our ordinations, whereas other churches are accepted. And this is actually unconstitutional. It's kind of separate from this matter, but what this law does is essentially gives them another way to officiate.
I think I can answer your question, Mr. Chairman.
Civil marriage.
Yeah, so to answer your question, Mr. Chairman, no one from out of state can be the wedding officiant unless they're a minister under current law. This would change that and allow me to allow my Uncle Joe or from out of state to come and marry even though he's not a minister. So that's number one. Second, current law requires a minister to have a congregation. If they don't have a congregation, they can't do it. And third, current law, even for Virginians, and I have been wedding officiant for 3 marriages, requires a very convoluted process where you have to go to court 4 times, get a court order, file a bond, get a notary, show up with $500 or a money order. This greatly simplifies the procedure. The old procedure dates back more than 100 years and says, let the parties to the marriage choose who they want their wedding officiant, not the courts of Virginia.
Okay, thank you very much.
Move to report.
Is anybody against it? Is anybody, any questions about this? All right, okay, it's been moved to report.
Mr. Chairman,
Oh, yeah, this is Steve. Is this rushing?
It is rushing.
Okay,
yeah.
we're rushing it.
This is not my area of the law, but I have concerns about the unintended consequences that the bill might present. At the very least, I would like this to be studied by a group of lawyers who deals in this area. My concern here is that this would permit people to get a marriage license and then designate anybody to be an officiant, but then there's nothing that compels, that requires that they then file a certification of it having been done and leaving in dispute whether there actually is a marriage.
Mr.
Again,
Chairman.
this is not my area, but I spot unintended consequences.
I can answer
throughout
that question.
Mr.
Actually,
Chairman, we've taken testimony, we have caucus now. I think we need to go by for the day on this, and then we've taken
Come
testimony.
back.
Steve, look over on line 66, 67.
the
68.
parties can return the
I think
certificate.
we'll
I've already dealt with that
We'll
issue.
come back,
All right.
Wednesday, and the committee will rise.
Okay, thank you. Be back Wednesday.